Yes, my lord, I am mentioning, my lord, item number 100 of the monthly list. Upon notice to the other side, my lord, for upgradation of a review matter.
Review of our order.
Yes, your lord. My lord, perhaps you remember a specific performance of agreement that matter, my lord.
My lord, is your other side ready or again adjournment?
My lord, I have told them, my lord, they also once mentioned for upgradation.
My lord, may I permitted to mention item number 74 of the monthly list. This matter appearing since September, my lord. It is senior citizen matter of
It
8
was
years.
called on.
My lord,
It was called.
my lord,
The entire combined list was called.
in the last month, my lord, I mentioned, my lord directed me to mention it the first week of January.
What is the urgency?
My lord, senior citizen matter, my lord.
Maybe, but what is the urgency?
But problem is that the property which was declared vested was rest by an order of stay. It was.
You are the appellant.
I am the appellant, madam.
It is relating to a property vested to the state.
To the state.
Then
Illegally. And I got lost in the tribunal, my lord.
wait for this month, sir.
My lord,
Let us see how we proceed.
since September, my lord,
You remind us in the month of.
last month I mentioned.
Remind us in the month next month. Yes.
My lord, may I prefer leave to file this appeal without certified copy? My lord, it is related to the SSC examination 2024. My lord, with regard to the height issue, my lord, we have two appeal lists there. Separate order has been passed.
What is the urgency?
Urgency is that, my lord, we have passed the cut-off marks and they are going to fill up the post.
When was the order passed?
My lord, order was passed on 4th December. It was served on 6th January. That's why, my lord, I could not appear before your lordship.
4th December, how it can be served on 6th January?
I don't know, my lord. One order was passed by the Honorable Single Bench on 29th. It was till date. It was not served. My lord, some problem is there, my lord.
How did you come to know it was
But I have checked up it on a regular basis.
You're sure?
Yes. But one matter I can.
So if it was not in the server, why didn't you tell the judge?
My lord, I tell the listing, the star listing once I.
You will not mention. We upgrade our matters in the server and we request the advocates to intimate us if any matter has been missed out.
Well, yesterday I mentioned before the
Yesterday, that is after a month you are mentioning.
Well, earlier I.
December was the order passed. You did
29th November was order passed. Till today morning the order has not been.
So if you don't remind the honorable judge, what can be done?
My lord, it is the court
the
of.
system of certified copy has to go then. Every matter we have to ask if you
I have applied for the certificate.
When have you applied?
My lord, yesterday itself.
Yesterday you applied. Now you know that it is a easy process. Let me go and tell this and it will be allowed.
No, my lord, I shall undertake that. I shall submit.
May I be permitted to mention?
When is the post is to be filled?
My lord, 21st onwards, the appointment letter will be given. 3,000 posts are vacant, line vacant.
Avoid this practice. Becoming a disturbing element.
I must obtain the certified copy, then I shall move this matter. I am saying. As because this is my fault, I could not intimate that.
Permitted to mention on contempt application.
Contempt of hard order.
Right.
May I mention an application, my lord?
Pardon?
My lord, application.
Application
my lord, urgency is, my lord, the
hand over the sleep.
contempt has filed.
New application.
New application.
Yes.
But may I file one new application?
Uh-huh.
Inclusion.
Where is your notice?
Lord, this is the notice.
Yes.
Lord, another prayer, my lord. May I pray for leave to file appeal without certified copy.
You apply, you get the certified
Lord,
copy.
yesterday I applied.
Then wait for some time. Wait for some time and then.
My lord, this was for my lord, the analogous hearing of the review and the contempt, my lord, is not appearing in the list, my lord. May I hand over?
What was our last order?
Last order, my lord, is directed to exchange affidavits.
When did we make it returnable?
My lord, in the month of December.
Huh?
December, my lord, it was made.
That is our order.
The order, my lord, I am not carrying today.
So it never happens. Whenever we give the returnable, it
My
comes
lord,
on
the
the day.
bench, my lord, perhaps was not available.
Which bench was not
My
available?
lord, your lordships, my lord, had passed an order. My lord, it
When
was
did
the,
we make returnable?
my lord, it was made returnable in the first week of December.
Show us the order.
My lord, I'll come. Today I am not carrying it, my lord, I will mention it on the next day.
Your lordship's praying for inclusion of content application.
This bench contempt.
Yes, sir.
New contempt.
Yes, your lordship.
Yes.
One appeal, my lord, when I mentioned in the month of November when your lordship was pleased to pass.
Which appeal?
Appeal is my lord, land matter relating to land
Is
matter.
it in the combined list?
My lord,
Remind
it
us.
was not appearing, my lord. I mentioned the matter, your lordship was directed to appear in the month of January, my lord. But due to some defect in the year of the appeal, the department has said mention appeal.
Year of the appeal.
Year of the appeal, my lord. Instead of 23, it was typed out 24. Then it is mentioned again. That's why I am mentioning, my lord. It was earlier mentioned.
Is it in the list?
Not in the list, my lord, but it will include in the list.
Which year matter?
In 23 years, my lord.
Are you mentioning about notice?
My lord. I am grateful.
Your lordship's praying another prayer for restoration, lordship. As the matter was dismissed for default on 4th
Where
September.
is your notice?
The notice, it's attached to her.
Near in. Yes.
Item number 4, my lord, we appear in support of the applicants, my lord. This is a restoration application and there is 105 delays according to us. We have also, my lord, taken out another.
Even 6.
Now, my lord, one thing I must indicate, so far as this restoration application is concerned, my lord, there is an inadvertent mistake, where a typographical mistake in the prayer portion. The order of dismissal is not, my lord, tied. If the lordship kindly grants us leave, my lord, we can correct it here and now, my lord.
No.
You're there, Mr. Mujum.
I am for
Lordship.
Respond number 6.
Lordship, I am for the respond number 4 and 5. I am.
No copy has been served in so far.
Affidavit of service.
Well, you have not served.
Affidavit of service, my lord.
IIT, then
My lord, IIT probably, my lord, that was, my lord, this is a transferred brief. I am extremely sorry, my lord, my senior friend was troubled. IIT is not a necessary party, but it is continuing since the, my lord, initial stage. Somebody has made them a party, they are not a necessary party. Yeah. Yes, but we couldn't, my lord, since when we received the matter was dismissed. Now, when it comes before your lordship, my lord, if it is
Serve upon them.
definitely, yes.
Serve upon them next
Here and now, my lord, I'm serving, my lord.
How many days delay in this?
105 days.
What is your explanation? What was the main matter
My
about?
lord, I will, my lord. My lord, affidavit of service may be kept with the record. Now, my lord, petitioners before your lordship, my lord, initially made out a case that, my lord, these are all these conversion from the contributory provident fund to, my lord, the GPF come, my lord, pension scheme. Probably your lordships has also, my lord, had occasions to, my lord, deal with some matters. Now, my lord, our case is that there are certain government circulars, my lord, since 1985, when the FAST scheme was floated. Then there was
The clients were not interested.
My lord, probably lot.
Advocates changed 2013 matter. They are not interested. Let us try our luck. Let me file a restoration.
My lord, it's not that. Lordship will
You
kindly.
people are not serious with your matters.
My lord, henceforth, my lord, since we'll be conducting the case, my lord, we'll keep in touch. The clients have kept in touch with the advocates, my lord. Probably in open courts, my lord, sometimes we cannot express ourselves in the way that we would have liked to. Lordship will kindly not take it in this way. These are all the persons, they have been pursuing their remedies since long. And I will, my lord, also, my lord, show when the matter comes up, they were diligent enough. Yes, my lord, there is the dismissal. The dismissal is very unfortunate. And second of all, my lord, in the array of respondent, my learned senior friend's client has been added, which also will short to be deleted, my lord, when the matter is restored.
What is the wrong in the order?
My lord, this is where, my lord, we will,
You
my lord.
exercised option in 1987.
Yes.
Thereafter, you did nothing for 14 years.
Yes, then there was, my lord, the departmental circular, which was not, my lord, placed. That if we get an occasion, will show. Now, my lord, 85.
Which departmental circular was not placed?
I will, my lord, in 1990.
You are the employees of the institute.
Yes.
Then why you're saying institute is not a necessary party?
Not IIT, IIM. I am the Institute of Management. IIT, Institute of Technology, was added. It was added in the reach stage. Now, my lord, when we received the brief, it's a transferred brief. We thought, my
You are
lord,
the employees of II?
Indian Institute of Management.
Very good. Now your option, these people have retired when?
My lord, on various dates, we have the club together.
There is nothing in the matter.
My lord, I will come before, my lord. I have been, my lord, assisting some other courts also, my lord. We had been.
Now, what is your explanation towards this?
I will, my lord. Lordship will kindly consider that in 1985, the scheme was flush floated. Previously, everything was contributory provident fund. Now, my lord, in 1985, when the government came up with a policy, the IIM adopted that policy that yes, for our teaching and non-teaching staff, we will implement that. Now, after 85, my lord, the 87 circular came in. Now, my lord, 87 circular, definitely, which your lordship has looked into, is definitely there, that you have to exercise your option to stay in the CPF. But if you don't exercise your option by the deeming clause, you will be treated, you are in pension.
That was not your argument. That was not your case also.
My lord, I will, my lord. Lordship will kindly, my lord, gives me an opportunity, my lord. These persons have been pursuing the remedy. I will, my lord, point out. I will point out, my lord, these circulars are there. These circulars are there. Lordship gives me one opportunity. I will not take much of your lordship's time. I will come up with a short list of date and I will, my lord, indicate that these circulars which are in vogue.
How are you, Mr. Mojumdar? You're keeping well.
More or less.
Very good.
বড় হয়ে যাবে।
I am appearing on behalf of the private.
No, I am appearing for the petitioner. But the petitioner before your lordship, my lord.
Subject to correction, there was a direction for filing of the supplementary affidavit. Your lordship kindly sees the last order.
Supplementary কিসের?
Subject to correction.
Oh.
Subject to correction, my lord.
Subject to correction কি?
So it's not there.
Direction was given, we can't recall.
But I may be wrong, my lord.
No, I don't know whether after that he wanted to file any supplementary affidavit.
In the server copy, my lord, it is being shown, my lord.
Order dated?
12th of December 2024. Oh.
Yeah.
But the year of the same cost title, Sonda Maiti versus State of West Bengal, WPLRT 128 of 2006, it is showing. It is there in the server. Instead of 2024, the order dated 12 December 2024.
12 December 2024. The matter number is wrong.
Matter number is WPLRT, but this is in the server. 128. এটা দেখান তো দর্শক।
ও না না, এই তো ম্যাটার নাম্বারটাই ভুল ছাপানো হয়েছে গো।
দেখি আমি দেখি না তোমার কি
It is
হচ্ছে।
LRT 28 of 2024.
2006. That is the
ছয়টা বলছি কিন্তু অর্ডারটা তাহলে আলাদা হবে।
কোন মোবাইলে করেছে?
অর্ডারটা আলাদা হবে। যাই হোক 24-এর জায়গায় 6 ঠিক আছে, কিন্তু
অর্ডারটা ভুল অন্য বলছে।
এখানে তো খুলে না রে, এখানে তো কাজই করে না।
এটা খুলে টুলে দাও না আজকে নাই,
তোমার কাজ।
পরদিন দেবো।
এটা কি এস?
ওহো, matter to appear in the daily supplementary, so এটা আসছে supplementary affidavit কথা আমি পড়িনি বলে আমার।
তুমি 6 লিখলে কি?
It should be 2024 instead of 2024. It is 2006 in the server also.
So, in the order dated.
No, there is no direction for supplementary affidavit.
By reason of a typographical error in the cost title of the order dated 12th December 2024, comma, the number of the
চ্যালেঞ্জ করে যাবে।
কোথায় ঝামেলা হচ্ছে ওই পার্কিং নিয়ে।
কি বললো?
সব
Head
14-7
accordingly, the said vesting has long been made absolute. এটার পরে আবার কি লিখেছে?
This type of similar issues are
কি similar
in
issue?
both the larger nature.
তাহলে
committee সম্পর্কে
তা ডিসমিস করলো কেন?
dismiss করো নাই তো?
ও
ম্যাথে 1400 ফেলেছে পয়েন্ট অফ মেনটেনেন্স
14/7/2025 আর এখন আমরা
এখন হচ্ছে এই জাল বাচ্চা হয়েছে এসটি দেখো
কি urgency? What is the
Urgency,
urgency?
Lordship. I am the bona fide owner in the land, my lord. As per civil court judgment is there, my lord. The state government is, my lord, restrained for disturbing and interfering the possession of
Hmm.
the land, my lord.
No, Mr.
And title was
Mr.
title.
Bhanna, the Landed Tribunal yet has not decided the point of maintainability as yet. Now you are inviting us to enter into the merit.
My lordship, kindly,
On 14th July 2024, the date has been fixed. Landed Tribunal consider first
Lordship,
maintainability. If
it
you
is
cross the hurdle, then the
it
Landed
is simple,
Tribunal
my
will
lord.
decide
It is
the-
simple, my lord. The patta has been granted my land to the third party, and third party, my lord.
Already,
Third party.
already.
Prior to his
It is
purchase.
not that
Lordship,
we are going to grant patta.
My
Patta has already been granted since long back. Land was vested in estate acquisition 1953.
thereafter, my lord, suit was my lord, lordship, suit was declared, the title declared.
Whatever you agitate your
How the state
points before the Landed Tribunal July.
Tribunal July, but
If you find that you should have made an application for preponement or anything,
and the lordship, the tribunal, what tribunal said here, last paragraph, the
tribunal
government
has observed nothing. Only observed that this type of similar issue are pending before the larger bench and honorable apex court of the country.
and in the meantime, my lord, my land has
That
been,
was
my lord,
subject.
my
Nothing.
land has been acquired.
Be that as it may, the matter stand
My
action.
only my
Please
prayer is
submit.
here that the HDO is the competent authority to decide the patta has been should be annulled. Patta.
What is your grievance before us?
Divan share, my lord, correction of record of as per
That we cannot do. What is your other grievance?
other given the others, the private respondents going to construct the building.
Go and tell the tribunal, file a preponement application.
And interim order.
Pray for an interim order.
Lordship, kindly pass this order on to maintaining my status quo.
Status quo for what?
Status quo.
Mr. Manna, this matter has been made returnable. You have come before us for expeditious disposal.
Not only this.
For
What
interim
order passes, the larger bench will see decide. Larger, what is the what meaning
Go
is
and
it?
file an application before them, Mr. Manna.
So our court has jurisdiction, lordship, pass this order, and only our court pass this order, my lord. Even the application pending before the HDO for annulment or what, HDO would dispose of my application pending before him.
Mr. Manna, learned advocate appearing for the petitioner, submits that by an order dated 5th July
কি হলো হলো
হলো মানে ওই তো তারা ভর করে যাবে।
হয়েছে তো কিছু ব্যাস আবার কি
কিছু তো হয়েছে।
Private party is going to construct building, our land.
ভালো তো
To fight it out with him. He's saying bhalo to. To fight it out with him. Why he will make such statement?
but I don't know whether Marriott is aware. He's still now he's doing yoga bam. 989 probably he's 89 in our Bharatsan room number 2. In a particular day, he used to show us yoga.
কপি হার্ড কপি দিয়ে দাও।
Hard copy, na?
এটা আজকে থাক, আমি দেখে নিয়েছি ওই
But the
কোন আপত্তি নেই।
সেটাই বলছি।
we need to physically exercise to deal with your matter.
Yeah, you have challenge your
Now I find sitting here, Chatterjee is also trying to pull my leg.
He is learning.
But point is very simple.
My lord, what it happens, my lord,
Ah,
this particular petition
yes, yes.
has been filed on 24th December before this honorable court, and only yesterday 9:45 p.m. he has been sent it by email. No hard copy, my lord. Kindly have to take it to consideration.
No problem.
700 pages
I have no
petition.
problem.
700
It
pages.
has not been
9:45 yesterday he has been
fully,
sent it by
he
email.
is more than aware myself because he is dealing the code with the code below. So that is not the point. It could not be served.
Next Thursday, you give a copy to him.
Point is very simple. If you will also allow me 1 minute time. Before the rain control authority, under section 17, 6 eventualities are given. If 5 is not fit in, 6 will apply. Residuary clause. Application made under section 17, subsection 4. And the materials of subsection 4 is available. In spite of that, tribunal proceeded residuary clause, taking no distinction between fair rent and market rent. It is distinctly different. Fair rent under the statute and the market rent are distinctly different. That has been clubbed together here and making it impossible for me to pay. Not only that, a suit has been filed. If it is above 10,000, I am subject to TP Act. If 14.4 is applied in stricto sensu, then it will be below 10,000. My suit will be under Premises Tenancy Act. This is the point.
My lord, in 2003, original plaint is under section 17(4)(a). Thereafter, I have filed an application for amendment for initiating proceedings under section 17(6). That application was allowed by the rent controller. Now, Justice Sanjeev Banerjee, as his lordship then was, in single bench directed the rent controller, since 2003 it is pending, you will have to dispose it of within 6 months. Now, the rent controller failed to discharge his statutory duty. That's why I have filed an application for contempt against the rent controller. By guardian vendetta, rent controller, by ignoring his own order that I shall have to proceed under section 17(6), he have delivered the judgment under section 17(4)(a).
Because 17.4 ingredients were matching, he has no other alternative. He
This
has
is
to
the case,
pass.
and the tribunal, after go through this matter, decided that this may fit case for applying provisions of section 17(6). That's why rent has been enhanced.
So two questions are to be determined.
Once
Whether
when
they
my
are-
lord is open, that only one point.
whether their West Bengal Premises Tenancy Act will be applicable or not. First question.
So this is
If this question is answered in affirmative, then the question will come whether the rent will be determined under section 17(4) or 17(6) or not. These two issues.
17(4)(a), 17(6), all are the provisions of 1997 Act.
Once can this look once 1 minute I will take.
Yes.
Section 17. Mr. Chakraborty, kindly once look to this section 17. Kindly see. There are 6 sub provisions. Kindly come section 4A.
Commercial 84.
Kindly come to section 4 capital A.
Yes.
For a tenancy subsists for 20 years, pause here. My tenancy subsists for 20 years or more in respect of the premises constructed on or before the year 1984, fit with my case, and used for commercial purpose, fit in my case. The fair rent will be decided as per this formula. If these three ingredients are available in this case, then there is no question of going to 4, 6, because can you see the language of 6? Where none of the foregoing provisions is applicable. If 4 can be fitted in my facts of this case, then there is no question from going to subsection 6.
So you forego your first point, first down, that whether the Premises Tenancy Act
No,
will be
premises-
applicable or not.
No.
You forego, we
I will.
will apply our
This
mind.
is my mistake. This is my mistake. This is nothing to do with the suit. This independent application has been filed for rent fixation of fair rent. In the meantime, a suit has been filed.
Actually, civil court has got no jurisdiction
To decide it. That's why.
Yeah, then.
That's why the proceedings
Then will be-
rent controller is deciding.
Yes.
Now I am questioning if 14, 17, 4A ingredients are available, then rent controller cannot go. I repeat, cannot go in residuary clause. This is the point. Yes.
Just
Feeling like-
কি আছে?
This is the only point, nothing else.
What is the scope of interim order, Mr. Vasu?
Interim order, if not passed, how it will happen? The which suit they have filed, that suit will proceed under TP Act. But there is no defense.
We will fix a date of hearing.
Yes, can you fix? This is the only point.
Or the interim stage
No.
for the tribunal.
We are not passing any interim order. With all the materials on record,
Yes.
then we can.
No
you
question of
can-
filing affidavit.
No, all the pleadings are on
Yes,
record.
It's the only point.
So we fix the matter to decide the issue on a particular date.
Yes, lots of.
Difficulty is if we proceed with the suit,
If any necessary documents, because
Paying rent at what rate?
at previous rent.
Previous rate.
And but as an interim measure, the court was directed to deposit certain amount that we have deposited.
rent controller initially.
So there is no requirement to pass any interim
No,
order.
The only thing is, if the suit proceeds, I will be in difficulty.
No,
No, suit and I don't
This
know
is not
what-
specified
what-
act.
What purpose the suit was filed.
Yes.
I am submitting
Ah,
paper.
The court, civil court has got no business regarding
And
the
I-
fixation of
Yes,
tax.
this is my fault. I could not make myself clear.
Yes.
If today the enhanced rate is taken as a suit, my rent, then I will be subject to TP Act.
TP Act.
But if ultimately your lordship's court held, 17.4, it will be below 10,000, then that particular suit will be governed under Premises Tenancy Act. If before lordship decides, if the suit proceeds under TP Act, then I will be prejudiced.
Suit for eviction.
Eviction, obviously eviction.
You tell the suit court that court has fixed the matter.
That I will say.
What
Certainly.
it happens, my lord, initially rent controller fixed a fair rent 8,000 something. They prayed for stay of operation of the order before the tribunal. Tribunal rejected. They challenged this order before this honorable court, and your lawsuits affirmed this order and directed them to pay initially 10 lakhs
They deposited that.
as a deposited amount.
That is
Now the tribunal, what it has been held by applying the provisions of 17(6), 8,000 rent has been enhanced at the rate of 25%, 16,000 something. Tribunal doubled this and with effect from 2003. This is 4 Ganesh Chandra Avenue. This is a commercial premises, a hub business running going on.
find
1,700 square. Jibon diesel operation is
But
going
I
on
have-
whole India.
I
Annual
think
turnover
I have-
30 crores.
But I
This
have
is the corporate sector, Jibon diesel company.
but I have done a right thing, not servicing. If without servicing, this is the submission. If I serve it, what I will stand?
After service.
What I will stand?
Yeah. Yeah. Your defeat.
This was filed in two
This is the problem, man.
two original
Yes, challenging the order of the rent controller, they have prayed for decreasing. I prayed for enhancement. Now tribunal clapped together, combined order, one judgment. Now 8,800 something.
The present writ petition has been preferred, challenging the judge
কপি হ্যান্ডেড ওভার। আমি না দেওয়া উচিত ছিল, দিলে এই যা করছে না দিয়ে
lordship.
ওটা লিখে দিলে আর পয়েন্টটা নেওয়া যাবে না। And that is why we are not ready.
Develop.
Line for the appellant this matter, my lord. Here, my lord, there is section 5 of delay of 35 days as per my calculation and as per the calculation.
Mr. Banerjee usually doesn't oppose section 5.
Still, my lord.
He's a person to argue on merits.
Yes.
Am I wrong?
35 days as per my calculation, as per the calculation of the court, 38 days possibly, my lord.
35 days. 35 days you have written.
Where is the order impute?
My lord, order impugn, my lord, I have annexed in the stay as well as, my lord, the memo. Here, my lord, may I, my lord, these are,
Any interim order scope there?
your lordships can hear out the appeal, my lord.
Seto we can hear out.
Kindly hear out, my lord. Here, what happened, my lord? May I, my lord, say the background of the issue?
দিনে কেউ কিছু বলেনি judge
না, না,
সাহেব,
না।
উত্তর দেয়নি
না, না, ওটা নয়, আমি মেরিটের কথা বলছি।
Discriminate between married women,
And unmarried.
treat them under the first category of dependent.
Yes,
You are the
married woman.
Mhm.
Married woman. Here, my lord, the appellant before your lordships is the wife of the deceased employee, son-in-law of the deceased employee, and married daughter of the deceased employee. The main prayer of the writ application is for providing employment either to the son-in-law, there is a provision, I will satisfy to your lordships, or to the married daughter. Initially, my lord, I move a writ application before this honorable court. This honorable court was pleased to, my lord, hold that married daughter as well as son-in-law, both either one is entitled for employment subject to certain condition. Now there was a direction to pass reason order. In light of that observation, they passed the reason order. In the reason order, they, my lord, opine in respect of only son-in-law, that son-in-law is not entitled for certain such and such reasons. They said nothing about the, my lord, married daughter. Married daughter. Thereafter challenging that
There are three petitioners.
three petitioner, but the
Widow,
widow asking employment for son-in-law or, my lord, the married daughter.
so widower, son-in-law, and married daughter.
Married daughter. There are
The son-in-law is the husband of which daughter?
same daughter.
same daughter. Same daughter.
Now they
Husband
passed
is
an order
well off.
that we can consider the son-in-law.
No, no, no. They,
Lordship, my
no.
learned
No,
friend
no.
is saying
I'm বলছি তোমাকে।
son-in-law has not been considered because he is well off. Having his wife, who is the daughter, should have been considered also.
Achha.
Means
So
husband
what
reached.
order did they pass after the matter was sent back?
They pass order that son-in-law is not entitled, and married daughter, in respect of married daughter, they did nothing, my lord. They have not considered anything in spite of the order passed by this honorable court.
Now, if the son-in-law is well placed, question of considering his wife does
Because
not.
there was a direction, my lord, for consideration either to either son-in-law or either one is entitled.
Very good. Then you challenge that order.
That order.
Now, what
The-
did the
this
court proceed?
Single bench, my lord, proceeded, my lord, and my lord,
Sorry, my lord, I must interject. Not only well off, they have to show that she is dependent on them and residing together.
well,
If they could not
well,
prove with son-in-law.
well, I will satisfy your lordship. Now, my lord, the single bench hold, my lord, that the married daughter, discriminating the clause of married daughter for providing employment is ultra vires to the Constitution of India. And, my lord, the married daughter to be placed in the first category of the dependent in the clauses of NCWA, National Co-Wage Agreement. Now, my lord, having, my lord, returned the finding in favor of the, my lord, writ petitioners as well as married daughters, still the writ application has been dismissed,
But Mr. Ghosh,
my lord.
if the husband, apart from the eligibility to be considered, leaving aside that aspect, son-in-law as well as the married daughter, but the essence of compassionate appointment is whether You were dependent upon the income and what is your financial status.
My lord, in the NCWA,
That you cannot ignore.
no, my lord, yes,
Now,
but,
it is a factual, it is an factual issue to be decided by the authorities if at all there is financial stringency.
no, that is
That
not,
has gone against you.
no, my lord, that,
Now, let us
my
understand
lord.
now, when that order is in vogue, can you take this ground that irrespective about the income and financial
Yes,
status of the
yes,
son-in-law
yes,
married daughter, then what will be the outcome? Suppose we today again relegate the matter to them.
my
They
lord.
will again repeat the same thing.
No, I'm not praying for any relegation. Your lordship decide the matter once for all, whether I'm,
Decide what
whether
will
I'm
you decide?
at all entitled or not. Because,
She's entitled,
so
but the entitlement has not been found to be appropriate for grant of compassionate approval.
now the question is, my lord, in NCW there are, my lord, two categories. One is first class of dependence. There are second class of dependence. In a second class of dependence, there are two things are required. One is, my lord, residential status with the deceased employee, as well as financial consideration. But in respect of first category, there is nothing is, my lord, required to be proved that I'm the financial requirement is. I'll satisfy to lordships and, my lord, the Honorable Supreme Court in respect of the NCWA.
Then petition has been preferred. Preferred. Now, you have annexed the affidavits.
Section 5 allowed.
No, we have not allowed. We have fixed it.
He could not believe himself that I did not open my mouth. I believe that was the problem. I'm deeply.
We will challenge the order of the trial court.
Opposition filed.
And I filed opposition.
May I permitted to file reply, Lords.
Your Lordship can give paper book, my lord.
Pardon?
Huh? We want a interim order.
Pardon, Mr.
Interim order that has been passed. That should be stayed actually.
You are challenging an interim order.
No, total. Actually, this matter was decided by the single bench. The this was dated 10th June 2024.
I challenge a departmental proceeding in the order final order. And my lord, the learned trial judge, my lord, if a judgment made judgment in my favor. My learned friend challenged the order on the ground that since he is a bank employee, he should have gone to the learned tribunal. That is the point he has taken here, that this court has no jurisdiction. But if your lordship kindly go through the judgment passed by the learned trial judge, your lordship would find that the learned trial judge considered all the judgment of the Supreme Court, that if there is a violation of principles of natural justice, he can come to the High Court directly. So your lordship has to decide that point. Let them file a paper.
Well, that is the point actually involved here. That insofar as this matter, this is under the bipartite settlement. It is under the provisions of the Industrial Disputes Act. There, naturally, that was the figure, that is the place that should have been there. Actually, they could have gone for he's a workman. He could have gone for the tribunal. What for tribunal was there? Without not doing anything, he has done.
So, Mr. Mojumdar, prepare your paper books. We will hear the matter. We will discuss.
In the meant of the stay of the order.
Otherwise, they file.
Why any contempt application filed?
No.
Yes, I filed a contempt.
I don't know.
Notice contempt notice has already been given.
Because they've directed the notion on benefit good stage. बोलने देंगे आगे आपने बोल
Shall be entitled to maximum benefit of others.
May I submit one thing, my lord? My lord, kindly direct them to file the paperwork within short period. Let the matter be heavenly hard. Whether I can come to the High Court.
But that contempt application, what will happen? That should be stayed. They're making a contempt application. Already? Have you filed the contempt already?
No.
Oh, no contempt has been filed. So they cannot file it unless your lordship decides this matter.
They have served the notice of contempt.
Notice
and served the notice of contempt.
You are entitled to pension.
I am getting
Already
pension from the date of my retirement, that is 2008.
And when was the order of dismissal was passed when?
2008.
That was the order of dismissal?
No, compulsory retirement.
Oh, very good. Now, when was you due to retire?
I due to retire 2017.
2017. So the court has interfered with the final order of compulsory retirement. And as you have not worked till your retirement, they have notional benefits have been given, not the actual benefits. You are not aggrieved by that.
No, I'm not aggrieved by that.
Then the issue is whether compulsory retirement order could have been tested by the writ court or not.
Yes.
This
is the point, whether I should go to the tribunal, even if there is a violation of principles of natural justice and other Supreme Court judgments are there, that if there is a violation of Supreme principles, I can come. Whether
you can directly come. You are a workman.
Yes, I have. If your lordship kindly go through the judgment.
It is the framed is by the Industrial Disputes Act. Whatever the.
My lord, kindly see, when the matter was taken admission hearing, this point has not been taken.
Is covered under section 2 of the industrial dispute.
Is covered under
My
section.
lord, kindly hear the appeal. I will argue on that point. Your lordship kindly see the judgment. All the judgment of the Supreme Court has been taken into consideration.
That's why you have come here. That whether that is.
We agreed by this order, yes, no.
Now, are you getting pension
I am getting provision, I have been pension
All
from
things are.
2018, 2008,
from 2008
from the date of
calculation?
compulsory retirement.
Passing of the final order.
Contempt notice দিয়েছে, contempt file করেনি। হ্যাঁ, কি করার দরকার নেই।
Have you annexed all the pleadings here? Have you annexed all the pleadings here?
It's not CBS.
No, no, have you checked up?
Not
No,
CBS.
otherwise again you will come and say some more documents.
No,
are
no, no,
needed.
no.
শুনলেই নিতে পারি, শুনতে
All
পারি।
documents are there.
Then why don't you argue? We will finish it off. Finish it off. You are ready, Mr. Mojumdar?
Well, I thought it that it will be.
No, that
Okay.
is why we are asking you. That is why we
Taking
are.
about Monday, my lord, I will have.
So Monday cannot be done.
Your lordship fixed a date. I will come back with this. That whether it is admissible or not. But according to us, we have paid something to them in the meantime.
Ashok, heard the learned advocates appearing for the respective parties. ওইটা পান রূপম ওটা ফার্স্ট অ্যাপিলটার ওই ফার্স্ট প্যারাগ্রাফটা চ্যালেঞ্জ করেছে হ্যাঁ তারপরে কি বলেছি না তার আগে বলো চ্যালেঞ্জ চ্যালেঞ্জিং দিস by in connection with the appeal an application for stay being can atho has also been filed and the parties have exchanged their evidence.
Lordship, it's my humble submission. If you may please allow a short adjournment and make please be keep the matter.
Item number 9.
Yes, Lordship.
What is the application, madam?
Your Lordship,
Application 5 of 24. What is the application about?
Your Lordship, on the last occasion, Your Lordship has given us the direction to coordinate with the department and come back. Lordship, we just need 1 week's time. We shall coordinate and come back, Your Lordship, with the department. Due to the vacation, we couldn't. Please just be pleased to allow us a 1 week's time.
So who is your other side? Have you served the application?
Yes, Your Lordship. Yes, Your Lordship.
Not this week. Next Thursday.
Grateful, Your Lordship.
My lord, in this matter, Mr. Dolapati is appearing due to his personal difficulty. Kindly make this matter not this week. Item number 10.
What is the matter about? What is the application? You know anything?
No,
Have
my
you
lord.
served the application?
Actually, the brief is not available with me, so I have been informed by phone.
Bapin Boiddo, he is there? Yes. Why you are standing at the ground?
My private respondent, petitioner, my lord, came and took private, no objection from me, my lord.
Oh, I
That
see.
is why I.
Oh, I see.
My lord.
You are there, Mr. Day. Have you got the copy of the application?
Yes,
Yes,
my lord, I have served all. After that, no
Oh,
objection was taken, my lord.
Next Thursday, next Thursday, Mr. Day.
Yes, my lord.
Yes, my lord, I am for the writ petitioner appellant.
Not my opinion for the response.
Today you are ready?
I'll do it.
ছানু জিনিস সবইকার জিনিস টেসিস করে রয়েছে চিন্তা করতে হবে
My lord,
Last 2 days I was in the nursing home because of my Mrs. eye operation in Susruth. But last time I took time on my personal ground. I felt it. Let there be any reason,
You are all
whatever
right.
it
You are all right now. You are
I'm
all
passing
right.
the days not by the grace of God.
Yes, yes. Yes.
my lord, the learned single judge, by its judgment dated 7th of August 2024, the
Mr. Ganguly, you are appearing for everybody.
all the state.
All the
The
respondents.
state respondent.
You can appear for the estate manager also.
Yes, I can.
Oh. Yes, tell us what is the matter.
Yes, not silly. My lord, a plot of land being leasehold plot lying and situated at Kolani for 999 years. It was
Yeah, give us 2 minutes.
lordship.
Subsequent assignment, vigilance solid property deed registration একটা ব্যাপার আছে whatever it সেটা অ্যাসাইনমেন্ট তাহলে ওটা হয়ে থাকলে লিস্টিকটা কেন রেজিস্টার হয় সেই গ্রাউন্ডে আমার সব অ্যাবিনিশিও হয় সেইটা
One thing, my lord, before starting, my lord, in this particular matter, connecting relating to this plot of land, in one writ petition, while Honorable Justice Tababodho Chakraborty is sitting singly, one matter your lordship was pleased to decide and pleased to set aside the impugned order passed. So, my lord, it is my duty to point out, if your lordship kindly see page 70 of the application.
No, tell us now, when was the termination order passed?
What
is the present state of the property? You are still occupying?
Yes.
You have built a house thereon?
Yes.
Now, what notice did you challenge before the trial?
They, by the impugned order, the authority concerned rejected my application for mutation, which was submitted on the strength of a registered deed of assignment.
Registered deed?
Yes, lordship. A registered deed of assignment. But I am placing one by one. But initially,
so the court said that all is ab initio void since the original lease deed was not registered.
Yes. Which I am.
Yes, Mr. Ganguly. You have proceeded on the basis of the lease deed.
No,
you have
Lord.
confirmed the
Facts of the matter is this, Lord. For any land of Kalyani, Lord, particularly, lease deed is mass. That has to be executed.
Registration.
How can it be originality died? He, without getting permission, he has transferred the land. 1 minute.
Achha, show us the order which you challenged.
Lord, your lordship kindly come to your lordship's order first. Your lordship's order, page 70.
Let us see the.
Your lordship's order come. Your lordship kindly come.
Show us the order which you challenged.
Yes. The order of the.
Full kore pass kore দিচ্ছ.
No, Lord. Your lordship has passed this order. Then reasoned order. Actually, they mean
show us the order which was challenged.
My lordship will find at page 74. The application.
পাতা নাম্বারগুলো ঠিক করে পাবো বাবা
সব করা আছে
74 का that is the reasoned order.
যেটা চ্যালেঞ্জ হয়েছিল
This order was passed in terms of your lordship's order.
Yes.
Not the one Bimalananda Rai got allotment.
Which year?
In the year
1990.
no. In the year, my lord, the lease agreement was executed. In
Your writ petition was filed in 2014.
yes, well, in the first
2015.
petition was filed in the year 2011.
No, that we know.
Yes, thereafter, challenging that reasoned order, the writ petition was filed in the year 2015.
15.
15.
Affidavits were exchanged.
No, they have not used any affidavit.
Then the matter came up for final hearing.
Lordship. Because there was a direction since the time for exchange of affidavit elapsed, liberty was granted for mention.
Your mutation prayer has been refused.
Yes, my mutation prayer was submitted on
Evidence.
Lordship will find at page 56. Page 56.
এই পাতার মিল নেই
Annexure P7.
আমার সঙ্গে আমার পাতার মিল নেই কেন
এইরকম কেস যদি বেঁচে থাকতো সে কোর্ট
দেখো পাতার মিল নেই
ওইটাই তো ঠিকই তো আছে পেজ 56 আমি দেখাচ্ছি
এখানে 69
ওটা কাটা আছে
the government has
reminder it is a reminder it is a reminder it is a reminder that is a reminder
ফার্স্ট পরের পাতাটা ফার্স্ট
possession, but this deed has not been executed.
সেটা তো অরিজিনাল এলটির ক্ষেত্রে
অরিজিনাল
সেটা পেন্ডিং থাকা অবস্থাতেই ও
সেই ক্লজটা এখানে
expired
how it has expired before execution of this deed may be executed in the concerning or the personal entity
তারাও তো অ্যাপ্রোচ করেন
by probated will accept.
You file your affidavits. Your mutation prayer has been refused.
Yes.
You are in possession.
I am in possession. My lord, since Lordship kindly.
Not your Lordship would kindly come to page 60. Page 60. Your Lordship kindly.
16 of the stay application.
0 of the appeal, my lord. 60 of this appeal, instant appeal. পাতার মিল নেই তোর সঙ্গে আমার
Yes.
Your Lordship kindly comes page 60 in my learned junior annexure P8. It has been written from the estate manager Kolani, UD department to Sri Ardhendu Kumar Chakraborty.
Original allot.
No, original is the Bimalananda there.
But
Ardhendu Chakraborty for transfer of the deed. He was to seek information from the concerned authority. I have got this circular which has been annexed by my learned friend also in the appeal. I don't want to, since your Lordship, it fell from your Lordship desires to have an affidavit, I am ready to file. But it was extended report in the form of an affidavit, it was filed before Justice Aniruddha Rai.
Oh, it was filed.
Report in the form of an affidavit.
Where is that?
No, that is, he has not annexed here.
You annex that?
Your Lordship kindly see that the order of Justice Aniruddha Rai, Lord, this is under challenge, that is at page 83.
Is it with you? That affidavit, is it with you?
No, it is not at present with me.
Very good. You annex that in your opposition.
That your lordship kindly come to the order of, if your lordship desires to come. Page
So
83.
we will go into after you come with your affidavit. What is the use of?
Yes, I will come with the full affidavit.
And you annex whatever the report you have filed before the.
In addition to that, I will report with my affidavit, then the report in the form of an affidavit with my opposition.
Annex that.
Annex to that. Lord, grateful to Lord.
The present appeal has been preferred challenging an order dated 7th August 2024 passed by the learned single judge in the writ petition being dubbed
Is being passed, he will never be interested.
No,
for
why not?
getting
Why
this
not?
matter. Lord, I will assure my lords, Lord, that no steps,
No,
stern steps will be taken.
let us hear you people. If there is any scope of interim order, then we will consider. Because as there is a direction, let us consider he's praying for an interim. Yes, tell us.
My lord, so this plot of land was allotted in favor of one Bimalananda Rai. My lord, during the lifetime of Bimalananda Rai, he submitted an application, page 36, for to the estate manager, the respondent here, kindly execute the lease deed. Lordship, kindly page 36. 6/6/2000.
Page 36. He has given me a copy. It is not telling. The pagination is not telling at all.
আচ্ছা আচ্ছা কারো থাকবে না তুমি দেখো
তুমি দেখো না, দেখছি তো। Pagination not telling. ক্লাসকে বলো একটু পেজিনেশন করনি ঠিক মতো করে, কি করে হবে? তুমি দেখো না, এইভাবে করলে হয়? আমি পাচ্ছি না, তুমি খুঁজে দিচ্ছ। কোথায় পেজিনেশন আছে এখানে?
ওটা দেখাচ্ছি না।
কোনটা দেখাচ্ছ?
এখান থেকে আসো।
এটা তুমি দেখো তো, কিছু পাওয়া যাচ্ছে না। এই দেখো না তুমি।
ওটা টাইপ কপিও দিয়েছি।
কোথায় দিয়েছো?
এই তো টাইপ কপি দিয়েছি। সেটা পড়া যাচ্ছে না, টাইপ কপি। পেজ 36 করুন। আগের পাতা।
এটা কি?
এর আগেটা খুলুন।
Where is that page?
মানে পেজ 36 annexer P4.
This was on 6th June 2000
by Bimalananda Rai.
Then this lease deed was of which year?
No, but Bimalananda Rai, there was an agreement for lease. Thereafter, he paid the entire payment salami. Thereafter,
there was an agreement for lease.
Lease
with the state.
With the state.
Have you annexed that?
Yes, Lordship will find that page 24 onwards.
Very good.
But since the copy was not legible, I am giving the exact type copy. Lordship will find at page 27.
27.
Yes.
Yes. Now tell us now what happened. 24. Then what happened? You made an
Kindly come page 29. Then it will be clear before.
29.
29. The Lordship will kindly take paragraph 6 in the middle portion of the said page. That we shall duly complete the lease of the said plot of land in duplicate with such period as may be fixed by the government after demarcation of the plot at the site. Now, the demarcation of the plot at the site was done. Lordship will find at page 34.
That was done on 16th of March.
To 1994.
And when was that lease agreement?
Lease agreement was executed.
Lease agreement has not yet been executed in favor of the
agreement for lease. Bimalan, that was executed on
in the year 1990. Lordship will kindly come.
1st August 1990.
1990.
Very good. Now you made an application on, there was a joint inspection.
There was a joint inspection.
And 63 was the certificate of.
63 1994 is the possession certificate.
Very good. Then,
my lord, since after demarcation of the plot, they did not execute the lease deed in terms of paragraph 6 of the lease agreement. The said Bimalananda Rai submitted a letter before the authority, which you will also kindly will find at page 36. That is 6/6/2000. Thereafter, no reply was given. Again, Lordship will kindly come page 37, 31st May 2001. Another application was submitted. This is to inform you that I have construction a part of dwelling house up to lintel level as per approved plan. Now I pray you to execute the lease deed. So a draft lease deed to be sent as early as possible and oblige and allow transfer permission. This was also submitted by Bimalananda Rai, the original LOT, on 31st May 2001. Lordship will find at page 37.
Then what is the next page?
No, the next page, since there was no embargo in the lease agreement, that I cannot submit any transfer application before execution of the lease deed. At any stage, I can submit the transfer application. That clause is also there. In terms of that clause, the application for transfer was submitted in the prescribed manner by Bimalananda Rai in favor of Ardhendu Kumar Chakraborty, inter alia praying permission.
No, what is page 38?
Page 30 is the application by Bimalananda Rai
to transfer
for transferring his leasehold interest in favor of Ardhendu Chakraborty, since deceased.
Where is that? Where is to Ardhendu?
Yes.
Then what happened?
Nothing has been happened. So no, they did not give us any. Neither they have allowed, nor they have rejected. And in terms of a deeming provision of the lease agreement regarding that time, there was a time that the application for transfer should be disposed of within a period of 30 days. That was not done. Lordship will kindly take that clause also. Again, Lordship, I am traveling to your Lordship.
Deeming clause was there.
Lordship, I'm showing Lordship. Lordship, kindly take paragraph 25, page 25, sorry, page 25.
In the agreement for lease deed?
In the agreement for lease.
There was a deeming clause.
There is not to transfer or assign the leasehold interest without the previous consent in writing from the government. The decision of the government shall be communicated by the lessee within 30 days from the date of receipt of the application.
Clause? Which clause you are reading?
My Lordship, will come page 25.
Which clause?
My Lordship will come sub-clause C, D, E, F, F. This was underlined during the underline. It was like
Not to transfer without obtaining consent. Very good. And where is the deeming clause?
well, the decision of the government shall be communicated to the lessee within 30 days from the date of receipt of the application.
Very good. Where is the deeming clause?
Well, that means, well, if the application.
Very good. There was no deeming clause. Now what happened? Now
my application.
You executed now without having the registered list, having the deed executed. He executed a sale deed in your favor.
Yes. Deed of assignment, deed of transfer. Because
the deed of transfer.
Yes, but because in the lease agreement there is no such embargo that without executing the lease deed, I can execute a deed of transfer.
No, you did not. First of all, you did not pay the money which was required.
No, I have paid. So there, after payment of the entire salami, entire consideration price, they granted the physical possession.
Have not acquired the right of a lessee.
Exactly.
Lordship. Balot, kindly
When
consider
did
this
you pay
aspect.
the entire money?
The entire money have been
Exactly.
entire money
Was reflected in
according to the lease agreement. The money I was directed to pay nearly.
Page 38, you have said, due to financial crisis, money needed for my treatment, etc. So you executed the list. Have you deposited the salami?
Yes, yes, yes. After depositing the salami, Lordship, kindly take page 33.
33. Very good. Now you made an application thereafter upon the execution of the sale deed, you made an application for mutation.
In favor Ardhendu Kumar Chakraborty
made an application
before the authority for
mutation.
That application was initially submitted.
Then that was replied page 60.
Yes. The initially submitted page 57, page 60. That was reply. And it was challenged.
Very good. Now show us what is this document you have annexed. This page 80.
Lordship.
This notification of 7th
The notification. This is the recent notification dated 7th March 2024.
After the order was passed.
Yes. Yes. After the before the after the order of their cancellation order was passed.
And
but before passing the judgment of the Honorable Single Judge, it was referred before the Honorable Single Judge.
So why didn't you bring it on record before the single?
I have already recorded. But kindly
what is which clause you are showing from this?
Lordship. Yes. But first, for the cases where possession, page 80, middle portion, capital A, for the cases where possession is with the allotee. Here, admitted fact, the possession was with the allotee. Bimalendu Rai, I have shown to your lordship the possession certificate, where the allotee has paid in full as per the order of allotment sanction order, and possession has been handed over to the allotee, and the allotee is still in possession. Execution of the lease deed may be done with effect from date of handing over the possession for a period mentioned in the allotment sanction letter subject to it. The offer of allotment has been made, and the allotee has either paid in part or has not made any payment, but possession has been handed over to the allotee, is in possession of the land in some way or other. In such cases, balance amount of entire amount, as the case may be realized first on pro rata basis in from allotee on current market value to be assessed by the IGR, including other arrear dues, if any, as per condition of allotment. Then the lease deed may be executed with effect from the date of handing over possession, or with effect from the date the allotee is in possession of the land as the case may be.
Then Mr. Chattopadhyay, now the guideline provides that the lease deed has to be executed even with the legal heirs of the original authority if they have expired.
Who is the allotee?
So the point of non-registration of the lease deed has not been waived by this memo of the
Yes.
I'm not that,
And
but
he's
my
never
submission
been
is
an allotee as on today.
what I am on, my lord. Subject to your lordship's correction, since the government or no, they have not taken any steps to cancel my deed of transfer.
How they will come to know about that?
We have submitted at the time when we have submitted
that was an
application.
that
But
was
this lease
that
deed
was
can
an
be
understanding
my
between
lord,
you and the original.
Original
this
allotee.
honorable
He
court-
has never been an allotee.
this honorable
As on
court-
his date.
This honorable court,
Never been an allotee.
this honorable court
He has not
on the self this honorable court on the self-same situation, Nimira Sarkar. On the self-same situation, directed the authority to execute the lease deed in favor of the transferee upon realization of certain fees.
কোনটা মীরা সরকার বলছো?
হ্যাঁ, দেখাচ্ছি।
তো Mr. Ganguly, tell now how much money they will have to pay. You
Not-
regularize.
He has not got any accrued right over this plot of land, original plot. And Mira Sarkar, not I do have this.
No,
টাকা পয়সা
My lord.
no, he taken permission from you, everything will regular.
Not, that is the clauses, not. That is
Second paragraph,
Yes,
paragraph
yes.
of page 81.
page 80. That is the circular of 7th March. 7th March, will not have circular.
In case after 3 lines,
Will not, may I read it out? May I assist my lord?
all in this way.
Will not
In
just
case the allotee transferred his interest right of allotee to the person, entity with permission.
Yes, it is there, with permission. Yes.
That it will say that without permission.
Yes, without permission.
And then go on.
Will not, he is neither a legal heir.
Post factum mutation has accordingly been done from this department. And execution of this deed may start with such person or entity in the manner to be notified by the administrative department. Now you can consider under this clause, admitted fact that he has not executed registered deed of lease, be admittedly according to you, he has not taken permission, but he submit, I made application, they have not.
No, my lord, your lordship kindly come to the reasoned order. Your lordship kindly come to the reasoned order. Your lordship kindly come to the.
Two way out, either he is to get the lease deed executed in name of the legal heirs of the original legatee, and then complete the process of transfer. He is saying here, or you invoke this clause and regularize this.
But original allotee. Original allotee is Vimalananda Rai.
Ganguly, this lease deed agreement you never cancelled. So this lease deed agreement was never cancelled till date. Now read that uncancelled lease deed with the guideline of yours.
Lord, may I,
That is what my brother is saying.
Lord, may I, Lord, just your lordship, your lordship kindly come to the reasoned order. Your lordship kindly took little pain, my lord, which was passed in terms of your lordship's order as page 74 of the appeal. Your lordship kindly see that.
You have stated that on 2 occasions you asked them, they didn't turn up.
They did not turn. Even
But
there
in
was a suspicion on the letter.
2000 and 2003. But he is placing that in 2001 he made pair.
2000 and 2001.
When there is a
2001.
suspiciousness about his prayer not, which has been reflected in the recent order, that is at page 75. Your lordship kindly see the last paragraph.
Mr. Ganguly, why don't we solve the problem?
We are ready, but he's.
There is weightage in your contention. We are not saying that you have no point. The matter can be, whether it can be resolved or not. How it can be resolved? Taking the advantage of your guideline. Today you can give permission to the heirs of the original allotee to formally execute the lease deed. Then everything, now lease deed is to be executed. Market rent has to be given. So they will give the market rent, they will execute the lease deed. And as regards the permission which has been given, you can collect the remaining salami, whatever dues is there, and consider it
But
as
on that very point, what
today. Suppose even if you take over the plot, the litigation will continue. If you resume the plot, then you have to call for auction. Again, you have to initiate a process. You will not be utilizing the plot. You need money for the plot.
But there are many persons who are deserved, not since I belong from that place, not I know that
Don't
the
identify
anomalies.
yourself with the
No,
client.
no, anomalies in these colony plots, particularly colony plots. Your lordship kindly come to the reasoned order. How the observation, not your lordship kindly come to the observation of the estate manager. Your lordship kindly come to page 75.
Technical issue. It's technical issue.
Lord, I will come back with the affidavit. I will explain anything. Your lordship hear it. No interim order can be passed. Lord,
এই যে না কি হবে কি? তুই তুলে ফেলে দেবে।
Lord, your lordship.
কিছুদিন
There are many person lying.
No, no, Lord, I can assure my lords, that no coercive step will be taken till the disposal of this appeal. That, Lord, your lordship kindly, this is my humble prayer before my lord, not to pass any interim order. I will come back within time with the affidavit, let him file the reply. Your lordship kindly hear out the matter and dispose of the matter. That is my respectful submission before my lords.
Or we can totally less interest to proceed the matter.
Otherwise, what happened, Lord, the appellant will never be interested to.
Why not?
ওরা তো পার্টি নেবে। ওর কি বাবা মা পেয়ে গেছে, ছেলে পেলে হয়ে গেছে। In case না না বাদ চলে allotee who transferred.
Transfer to the person, to person. With permission দেওয়া হয়নি বলেছেন।
পারমিশনটা দেওয়া হয়নি, এক্সিকিউট তো করতে হবে। লিস্টটাকে তো এক্সিকিউট
Execution of lease deed may be done with such person, মানে যার against ইয়ে করে। এই ক্লজটা দিয়ে যদি কনসিডার করা এই
এই যে প্রথম থেকে পড়ো, in case the allotee has expired, execution may be executed with the heirs
concern legal heirs
or entity having right by virtue of probate will for the unexpired period. In case the allotee transferred the interest to the person entity with permission prior or post facto or mutation has accordingly be done. এখানেই তো রিফিউজ করে দিল। From the done, then the execution may be done with the person entity. যদি এই পারমিশনটা যদি ওরা দিয়ে দিত তাহলে মিউটেশন করে
এইখানে ঢুকে ঢুকে এই পারমিশনটা দেওয়া হয়নি, ওইটাই হচ্ছে
ও দেবেও না পারমিশন। ও বলবে এই ক্লোজ আমি পারমিশন
in case of original allotee
একটু চলছে না।
Terms of this course, this case, can, but admittedly he made application, but since application had
In case the allotee transferred with permission, তখন করতে পারতো, পারমিশন নেই। এখন পারমিশন in the admitted absence of permission and in the admitted rejection of the prayer for mutation, whether can be again dedicated to them. Ashok, the present appeal has been preferred challenging and order dated such and such, passed in writ petition number such and such. So, hard Mr. Chattopadhyay, ওটাই লিখো তুমি। নটারি for substance দেবে না বলে অনাধিকার 4 weeks কত বলেছো?
6 weeks.
4 weeks 2 weeks করেছো তো? কবে শেষ হচ্ছে?
22 February.
আচ্ছা, তার list the matter for further consideration in the under the same heading in the daily supplementary list of this court on 26th February. On 26th February, তারপরে ওটা দিয়ে দেবে Mr. Ganguly submits upon his in the meantime. ওপরে evidence of service as filed be kept on the file. No, mutation. Mutation to একটা status এইটা yes, next.
Yeah, applying for the respondent. Petitioner. Oh.
So this is my appeal.
But they have, your pleadings are on record.
Yes.
It has been assigned to us.
Yes. The order passed by the learned single judge was sitting in the appellate division bench, my lord. That's why the
Very
matter.
good. You have not filed paperwork.
No. This is the stay application.
Oh, stay application.
Stay application.
Now, my lord, kindly appreciate one aspect. The persons who are actually involved in this case, they are all employees of the port trust. I mean, port trust.
Let me start.
No. Kind of bolchi. For the last more than 30 years, they have been working. Still, they have not been regularized. Anyway, other benefits they have been deprived, given. Now they will read applications. Before that, it was referred to the tribunal. Tribunal kept it pending for years together. So virtually only by this time, some employees are already expired, some was going to retire. So their position is precarious. If you will also again direct, because though there is a directions by the court at the first instance, within a month, effect to be given. After expiry of the month, the paper application delay. I did not file any contempt applications with that expectation to be heard immediately. Once the appeal paper is all right, no problem. But we didn't file any contempt applications.
But you can take up the appeal at 816.
So kindly hear the appeal itself, my lord. Because ultimately what they will get.
Final hearing is stay application status.
May I
There is no scope for any interim order.
Yes. There is.
What
the interim order is required, my lord.
What I'm on, my lord.
The order, one writ petition filed by me challenging the award, and another writ petition filed by my learned friend for implementation of the award. This is the two writ petition. The order was passed analog in one order. I have filed two appeals here. The whole contention is this, my contentions. This worker, they were appointed temporarily basis, not against any substantial post, vacant post. They are saying against the vacant post. My submission is this, not against any substantial post. This is the number one. While the order passed by the learned single judge, taking into consideration that both the writ petition have challenged the award. But my learned friend has not challenged the award. I have challenged the award. Arbitral tribunal passed an award to implement, to absorb them from the date of passing of the award. Whereas the learned single judge passed an order to give employment from the date of the reference. This is the one aspect. And another aspect, my lord, what is the reference before the tribunal? How the tribunal dealt with the reference, and how the High Court has dealt with the reference. The reference is whether they will be absorbed or not. This is the whole question. While passing the award, the tribunal has said the unfair labor practice. Your lordship is aware what is not in the reference, that the tribunal could not go beyond the reference, number one. And court also cannot go beyond the reference. That was the second my challenge to this. First challenge is the order is passed, considering both the writ petitioner has challenged the award. That is not the fact. I have challenged the award, they have.
Yes.
And second is that they are beyond the reference. This is the whole case. And third is they were not appointed against any substantial post. I will substantiate all the papers as here, man. This is the whole issue involved. Nutshell of the matter is this. Now, your lordship kindly see, and while they have filed the statement of claim before the tribunal, my lord, not a single averment or argument or evidence that unfair labor practice is there.
Yes.
Now, your lordship, you can see the impugned order first.
No, what interim order for the purpose
Interim
of
order, if I,
interim order?
they can execute. If I not absorb them, they will go for
For the last few
section
months,
29
more than
for
one year,
Industrial
we did
Dispute
not do
Act.
anything. We could have filed an application for contempt.
Then let them say they will not file any contempt. I don't.
That is already there. I just advise my client
No,
that
not there.
I
You
can
record
assure
that.
let the appeal be heard by.
No problem. I don't mind.
Kindly see when the judgment was passed and what is the last direction of the judgment.
You prepared the paper books, Mr. Judge.
Whatever your lordship direct, I will prepare it. I'll prepare it. I'm ready.
Well, kindly
Yeah,
short the
everything
time.
is
But
there.
otherwise,
Lordship
it
will not
will
paper
be, even if the appeal is dismissed, may not be dismissed. My 50% of my client will not be able to enjoy.
No, that is from the not today.
I'll show you from the judgment, but you'll find that
first paragraph.
and everything is there.
Judgment, first
It can be
paragraph.
heard.
First paragraph, lordship, you can see. Page 24.
Appeal is within time.
No. There's a delay.
Delay?
If I'm not wrong.
No. What
No.
my
All right. But wait.
No, it could have been in the endorsed by the
Kindly see,
department.
but no, I may be wrong. Doesn't matter. Kindly see the last part of the order. Within a month of this order,
That's why I
be
prefer an appeal.
implemented.
That's why I prefer an appeal.
After expiry of that period, they paper an appeal. I could have filed a contempt application. I didn't do so.
Did not so.
Mr. Banerjee, we will ask them to file the paper books within a time, and we will hear the appeal. Paper books, then you hear the appeal. Finally, in the meantime, you undertake that you will not proceed with the contempt. Otherwise,
proceed with
kindly
the
appreciate one aspect, my lord. If all the papers are there, what is my anxiety? If all the employees died, my lord, what is the use of proceeding with the appeal? My lord, after serving, everything has been considered by the trial court. In the trial court judgment, everything is considered.
if you are for the interim order purpose, if you say that you are not proceeding,
I did not do anything for the last few.
we are going to record, na? That is why.
Lordship need not record. I can assure us. It is in our hand.
They have filed.
Kindly see the last part of the order.
Second writ petition.
Kindly see the kindly have a look to the last part.
Second writ petition for implementation.
Last part of the order. Last part of the order.
They have not taken
Second writ petition
for implementation of the award.
Kindly see the last part of the order.
The two writ petition. One writ petition filed by me challenging the award. And their
Our was the
implementation of the
kindly see,
award.
my lord. Our was the first writ petition for the implementation order. They waited so long. After a long time, they came with a second writ petition.
So what we will do, Mr. Banerjee?
Let
you
me-
are saying
let me-
that don't consider interim order. I will not proceed with.
Kindly appreciate.
Again, you are saying that no, you cannot do.
No. So long what I did, nothing. Kindly see the last part.
But for that, Mr. Banerjee, suppose tomorrow if anything is done, he can always pray for an interim order, na? When the appeal is to be heard, which you have both agreed. So interim order, very good. We are not going into the details of the matter to stay the order. If you say so, we will record that and fix it. That is for you to decide. If you
Kindly
say
see
that
the
no,
kindly just one, last for the order. Contact of the parties is very, kindly see the take trouble.
yes,
Within a month. Kindly see. Within a month. Kindly see. Hmm?
What is within a month?
24. Page 24.
Page 24.
24. এটা দিয়ে আছে তো? Yes. Huh? Inner page 24. After the judgment is Avilos got it, my lord. After the judgment is delivered in court, learned counsel for the workman prays for specification of a time frame of its implementation. Let the judgment be implemented by the port trust within a period of 1 month from date. That is, when the order was passed, 18 March 2024. There is no stay order item to anything.
We are not disputing that.
Then, my lord, what is the use of passing stay order? Kindly hear the appeal.
So yes, we will hear the appeal, we will fix up the date, but in the meantime, you cannot take any coercive steps against.
What coercive statement I'll take?
So that we have to record, Mr. Banerjee. Otherwise, how?
Kindly garden, my lord, kindly without me undertaken, kindly grant the stay, my lord. Without my undertaking, my lord. Kindly, as you lost these things, my lord.
Yes, then we will hear you as regards the stay. We will hear you. Yes, you place. Both
Because once I give the undertaking, my lord, that means I'm passing myself. Tomorrow I may not be here. Then another gentleman will come, maybe as a lawyer. He says, how is it? Why the undertaking was given?
Fix the appeal. Don't take any coercive step. That will suffice the problem. Don't take any coercive steps.
I cannot get coercive step. I can only file a contempt.
Because otherwise they will. Because they'll proceed under section 29.
So long we will do so from March 2024. Near about 1 year we didn't do anything. What is it? Sorry, my lord. Sorry, I'm sorry, my lord.
Yes, tell us why the order is bad.
Yes. Lordship, kindly see the order first. Hello. Lord. Huh? 816, kindly take 816, match 816.
Mat 816?
Yes.
No, for 815 we have taken.
No, 816, kindly, Lordship. Page the গন্ডগোল হয়ে যাবে একটু মেমো থেকে দেখাচ্ছে না 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 মেমো থেকে দেখাচ্ছে No, this is my appeal against my writ petition.
Order to the composite order.
হ্যাঁ ঠিক
একটাই তো order.
ঠিক আছে
You preferred a writ petition for what?
Writ petition challenging the award passed by the in tribunal.
And Mr. Banerjee filed the
writ
For the implementation of the award.
Mr. Banerjee filed a writ petition for implementation of the award. Now you can see the first order. Order page 24 of my stay petition. First paragraph. The two writ petitions have been filed challenging the award dated 1st August 2019 passed by the Central Government Industrial Tribunal, Kolkata Refinery. Threshold, it's a bad.
Page 24.
24.
Paragraph 24.
No, page 24, paragraph 1.
It time I'm just taking 5 minutes time. I'll come back.
Yes. Page 24.
4, para 1. Opening paragraph of the order. And order impugned.
Yes.
Yes, you have stated
That's
that it is wrong observation that you have challenged the award. They have came to implement the award.
Implement.
You have stated.
So this is not the correct. Number 1. Number 2, since they have not challenged the award, the learned single judge has modified the order, directing to pay all areas and absorb them from the date of reference of the matter before the tribunal. The Lordship can see the award.
Yes.
Award is at page award details also 140, 158. Kindly see once more.
Where is the finding that they are not against permanent vacancies. The court proceeded that they were appointed in a permanent vacancy.
Kindly see Lordship paragraph. My case is paragraph 5 of the stay petition.
Show us the finding of the court.
Paragraph 5. Right? Short facts is there, man. Kindly see paragraph 5 to 8 only. Nothing more. 5 to 8.
Court construed it as an irregular appointment, not an illegal appointment.
Irregular appointment.
Irregular appointment can be regularized by the
Yes.
court. That is what the court has done.
No, it's not irregular. It's a regular appointment in the sense some people they were appointed regular. Subsequently, those persons who are working, balanced persons. That's why I'm not sure.
No, show us, Mr. Jana,
Kindly see
that Uma Devi is clear.
Yes.
That no backdoor appointment.
Yes, no backdoor.
And those who have entered through the backdoor has to leave through the back.
Yes.
Very good. So, but they are subsequently the law has been proposed. We can say that it is explained to the effect that if it is not an illegal appointment but an irregular appointment, the employer can always be directed to correct the same.
But this is not an irregular appointment.
Show us that is an illegal appointment. On what basis they entered into service?
They entered in, that's why Lordship can see paragraph 5. Paragraph 5 to 8. Lordship can see page 4 of my application.
Thought that then we have to go through the entire judgment, Mr. Jana. You tell us where is the finding, what is the wrong to get a temporary, get an interim order.
Anyway, I'm showing the where is the wrong in the order. I'm saying. Then Lordship on page 26, your Lordship will see the order. See the order, paragraph 11. On the failure of the port trust to permanently absorb the said 61 workman conciliation proceeding were initiated under the provision of the Industrial Dispute Act 1947. Upon failure said proceeding, central government referred the following question to the central government tribunal on 23rd May 2006, followed by a correspondence such and such. Whether the action of the management of Kolkata Port Trust, Kolkata, in regularizing the service of 61 workmen as per list annex such and such, engaged on temporary basis on the permanent post as mentioned against each name in the list is legal or justified.
Temporary engaged against permanent post.
Temporary against the permanent post.
Yes.
So subsequently we have not appointed. So, there are some vessels as there. They are appointed on the particular vessels. Now when the vessels is condemned, that we do not require any appointment to that effect, my lord. So those people were appointed temporarily because we have sent the name to the employment exchange, out of which we have appointed some persons. Thereafter the vessels were condemned, we have not appointed any other persons. They were appointed as a bodli or whatever, maybe as a temporary employees. প্রথম লাইনটি ভুল বলেছি সেটা বলেছি রেফারেন্সটা ভুল So these are the references, they are temporary basis.
Yes.
By paragraph 14, your lordship kindly see. After discussing the evidence come on record, referring the argument of the party, tribunal found that workmen were engaged contractually for the specific period mentioned therein. The tribunal found nothing on record to show that the workmen concerned were appointed against the substantive post. The tribunal found that the decision of the Supreme Court to say state of Karnataka such and such, would be bar against the regularization.
These findings were never under challenge.
And this finding never challenged, either in the writ petition or any time by the worker.
Which finding?
This paragraph 14. Paragraph 14, tribunal finding recorded by the learned single judge.
লিস্টটা একষট্টিটা এলো হচ্ছে কোথা থেকে আরেক অংশ সেখান থেকে
What was the total number of vacancies?
Yes,
Now around 30. কত হলো এখন 30.
No, you
this fact
53.
50.
In 1995 you called 350%.
আমি বলে দিচ্ছি।
না, Madam, I leave.
There were two sets of appointment, all in 95, 96. First, in respect of died in harness category, 350 persons were appointed, of which 264 were permanently employed.
all were died in harness category vacancies?
No, there are two categories.
One is died in harness.
One is died in harness category, the other is through employment exchange.
Yes.
But those are in fact also vacancies arising out of death category.
So total 350 vacancies were there.
No, in the first category, which is died in harness category, 350 were appointed,
Achha.
of which 264 were permanently employed. 86 were remaining. Out of this 86, again 42 were permanently employed. Therefore, 44 remained. Out of 44, 5 died. And 39 were seeking regularization. This is one set. In the second set, which was sponsored through employment exchange, 52 persons were engaged,
Yes.
of which 35 were permanently absorbed. Out of remaining 17, 3 died and 14 were seeking regularization. Therefore, 39 plus 14, total 53 persons were before the tribunal.
The High Court got 61.
Para 40.
The para 5, the remaining 60 odd.
But 61 is the Honorable Single Judge included the dead people, 5 and 3. 5 of the first category, 3 of the second category. So 5 and 3, 8. With 53 becomes 61.
8, yes.
Now, my lord, 2 writ petitions were filed. One by the employer, my client, challenging the award. The other writ petition was filed by the employees, obviously, for the implementation of the award. My lord, the basic approach of the Honorable Single Judge is incorrect. It is evident from the first line of the judgment.
That he has shown us.
Yes. Now, this is number 1. Number 2 is, going by the reference was these people, please take me, Mr. Jena has read it. Please comes to me, Lord, paragraph 11 of the judgment where the reference is quoted. This is very important.
Yes.
Whether the action of the management of so and so in non-regularizing the services of 61 workmen engaged on temporary basis on the permanent post. This is very important.
on the permanent post as mentioned against each name in the list is legal or justified? If so, what relief? My lord, on the permanent post aspect, my lord, the tribunal has held against the workman. There is no challenge to this finding. That is what, my lord, Mr. Jaina was placing from para 14. My lord, if that is not challenged, my lord, the learned single judge, my lord, could not have, my lord, overridden or upset that finding.
No, paragraph 14 says
Yes.
only that after discussing the evidence and referring to the arguments,
Yes.
tribunal found workmen were engaged contractually.
Yes.
For the specific period, the tribunal found nothing on show, nothing on record to show.
Yes.
So he omitted to consider the records. That
Yes.
is the observation, but that does not mean that they issue that they were not substantive vacancies, they were not engaged.
My lord, I can, my lord, challenge.
Challenge to this, Mr. Dotto, what will be the challenge? Because tribunal said that
No.
Tribunal found nothing on record.
Yes. Now kindly take my paragraph 16 where the finding is there. The tribunal answered the first part of the reference, that is, as to whether the action of the management in
That is unfair practice.
Yes.
Where the action is non-regularizing, say on the permanent, in the negative against the
workman. So this is the finding of the tribunal that has to be challenged. But I'll take your lordship through the relevant portion of the award. Well, my case was very simple.
Mr. Dotto, what is paragraph 16? Tribunal answered the first part of the reference. What was the first part of the
Yes,
reference?
please come back to me, Lord, paragraph number 11.
11 was whether the
Action of the management
in
of so-and-so in non-regularizing, so-and-so engaged on temporary basis on the permanent posts is legal and justified. This is the first part.
That one was not included. Engaged on temporary basis on permanent post.
Yes,
that portion was not quoted in paragraph 16.
I see. But my case is that as per the reference, if they are not engaged against permanent posts and the tribunal having held in my favor and against the workman that they were not engaged against permanent post, the matter should have stopped there. The tribunal could not have,
only on the basis of paragraph 16.
No. I'll come back. But my paragraph.
When can you prepare your paper?
Give us a reasonable time. সব কাগজ তো আছে তো। But all the papers are on record. Your lordship may treat the stay application as the informal paper book.
Have you preferred any contempt application?
No. But let them give that assurance, and lordships may hear out the matter. Some assurance
All
may be
the
recorded.
records are here.
Reading, my lord, they also state.
My reading won't help. Have you checked up? Have you checked up? Your award, your everything was.
Whatever was placed before the learned single judge are all there in our stay application.
You have not filed any contempt, no?
No, we have not. Well, let them give that assurance, but I'm not paying for stay.
No, how can
I
you
am
say
put-
don't file the contempt?
No. But I have to make some payments, but I am running out of time. But if your lordships hear out the matter on an early date, and if he says that he is not going to press for contempt, I will not trouble your lordships with a prayer for stay. My prayer is there.
Was exactly submitted by Mr. Banerjee. That was actually.
You do not press for contempt in the meantime.
Questioning the legality.
I will not record that, but Mr. Banerjee already submitted.
Questioning the legality.
No,
We will say that you will not press for contempt of the order in the meantime.
This is not our undertaking, but your lordship sort.
No, you are saying that hear it out, we will.
24.
What you have you talked with Mr. Banerjee? Decide. এতক্ষণ বলার পর
Your lordship, my lord, must order, but not of the our assurance.
2021 and WPA 8919 of 2021, comma, which are analogous.
Assurance record for বলেছি যে আপনি আপনার সাবমিশন ছিল not to record our assurance.
কোর্ট যদি মনে করে stay দেয়, they are able to hear. Yes, sir.
Mr. Jena Preetana? ঠিক আছে,
all
ঠিক
papers
আছে।
are here.
Yes, next.
So may I leave, my lord? No, আমাকে ছাড়েন।
24.
এটা নিয়েছি। তুমি থাকো।
24th February 2 p.m. ডায়েরি তে নোট করে
No, it is that tribunal matter. But do your lordships require my assistance? This matter, Milord, where Milord, your lordships were pleased to direct the tribunal to dispose of the matter within a certain particular
You
period.
have seen the comment, Mr. Dotto.
ওটা দুটোরই ছিল, দুটো অর্ডারই এক দিতে হবে আগেরটা
We were not at all, we didn't want also to
Right.
ask for, but this, if this becomes a practice, it is not a question of only one person. You will remember, you will be there in the profession all time, but this sets a bad example.
Right. But I've told Milord, it has been disposed of by this.
Explanations has not been given properly.
Affidavit দিয়ে দিয়েছে,
হ্যাঁ?
full of
Even
reports.
explanations has not been given properly as your lords wanted.
না, ও তো দেখে নিয়েছে, affidavit তো জজ সাহেব দেখে নিয়েছেন অনেক আগে।
It has to be.
Because in the order,
has to be appreciated that this matter cannot be had and disposed of as expeditiously as this.
He has,
Although you have paid for apology, but we are not bound to accept.
No, certainly. not.
certainly, lordship may grant.
Certainly.
Yes.
and there was this,
Every
and
the
this,
authority to consider.
and this honorable court, there are short for specific explanations, my lord, that he shall also categorically put it in record who according to him ought to have appreciated that the matter cannot be heard and disposed of as expeditiously.
He had no answer, that is why I said pardon us.
That no answer, only pardon.
He had no answer for that, so he said pardon, apology.
And if the explanations given by respondent number 8, even if it is, my lord, taken to be accepted, my lord, then the entire responsibility has been shifted to respondent number 7 regarding as regard to the violations of the order.
But he has also taken responsibility stating that I have not
Under
fixed the date.
under the instruction,
I have not fixed the date on one line. I have not fixed the
I have been orally instructed.
এটা দাও না,
As there was a congestion in the docket or anything like
No,
that.
oral instruction by the chairman.
As there was huge number of enlisted cases.
Lordship may kindly do not, my lord, they are very remote, my lord. এখন সব মামলা time to time নিচ্ছে। হ্যাঁ, they are very, we have
As
no
a result,
explanation.
my lord,
We have
what
no
happened,
explanation.
my lord, that the matter was relegated to the department, my lord, then once again, my lord. So we have already in a hasty manner, my lord, we have already filed an application challenging this order, my lord.
No, no, your writ petition
you-
has become infructuous. We are not.
Your
on
lordship
that
spoke
level.
to
My lord,
take up the- took
that
up
they
this
have
issue.
already passed, my lord, then we have already,
Dispose.
yes, my lord, and against that order,
Did you have a talk with this
Yes, my
chairman?
lord. Now, my lord, they are taking up the matters, my lord.
Are they apologetic, or you
They
said
very
that file that formal application, then I will consider.
They are very much apologetic, my lord, and now the matters are being taken up on the returnable date, my lord. These matters are being fixed on the dates which are there mentioned in the form. So they are very much apologetic. Lordship need not, your lordship need not look into these affidavits, my lord. They are very much apologetic.
One's brain
And advocate general is here, my lord. He has also
Don't
advised.
say any word, only.
But in fact, my lord, unofficially, my lord, I can tell your lordships, I also spoke to him. I told him that
If I am not willing to do my duty, I should step down. Because you people will come and say, my lord, you are not delivering the judgments in time. You are reserving the judgment. You are taking the time. So let me put at him. I said, Mr. Dotto said that judgment is to be given by Sajja. I shall not give the judgment. And I want to see what Supreme Court will tell against my comment. If this is the practice of the state tribunal by a person who happens to be a bureaucrat, upon retirement he took up this job. These people does not understand that he is adorning the civil chair, the chair which is delivering justice to the people. Tomorrow you people will come and throw dusters on us. What judge you are? You cannot deliver judgment. We are waiting for such comment now. The situation has such come. This had never been the practice when Mr. Dotto, you have a huge experience. You have seen. How many thousands of contempt matters you have appeared? You have dealt with the court. Don't take it seriously. But the thing is, these registers.
No. Milord, so far as the dignity, majesty of the court, Milord, we being the members of the bar, we cannot defend all these things.
Yes, that is why you are maintaining sobriety. That is what is sobriety called.
Right.
That I will maintain sobriety. I shall not speak as counsels when you appear. It is very rare when the advocates misbehave with the judges. Because that is the dignity. Today a layman, how will he understand? Say, he will go to the say, see what.
Injurious to the majesty of the court.
Right. And your lordships should
And
all.
then, we are to hold that acceptance of the apology will not be injurious to the majesty of the court.
Milord, I add to that.
Yes.
The apology should also not be to evade the process or evade the consequences.
Yes.
I add to that. But I felt, Milord, if your lordships have some trust in me, I felt
Oh,
that
if you had been the person, we had no problem.
No. Speaking
Because
for him,
we have seen the advocates. We have seen the advocates from this side of the bar. If my office, my advocate is my officer, because we have a relationship together.
Right, sir.
We can at any time we can call you, call Mr. Dotto, call Mr. Siddiqui. Why? Because we have faith on you people. But if this member petty, what should we not said?
যদি actually ওই একটা মার্চ করে গেছে ফাইনাল অর্ডার শুনেছি সত্যি চিন্তা করি okay we are thinking over it and taking it all
I leave it to your lordship's wisdom, Milord.
You will understand, Mr. Dotto. He will understand, but a layman will not understand. You people will understand why the court is, even if we do not issue a suo motu rule of contempt, we have the jurisdiction. Suo motu rule of contempt we can issue, but you can understand, he can understand. But what about the litigants, Mr. Dotto?
I had, my lord, certain ideas which, as a advocate general, I cannot express about, my lord, the functioning of this tribunal and the requirement of these tribunals with bureaucrats. But now, my lord, I cannot express my mind.
How? Why?
Yes. Sometimes
Wednesday 1 PM order দিয়ে তো
get flat.
কোনো কিছু আছে Wednesday?
Thank you.
Ultimately, petitioner has suffered.
আরেকটু দেরি করে রাখবে, চলে যাবে। একটু রেডি করো না, কনফিউশনে আমি লিখে তোমায় পাঠিয়ে দেবো। Any reply to that শোকস?
Yes, exception. We have
ওই একটা এক্সেপশন আছে, আর ওই দুটো আন্ডারটেকিং দিয়েছে।
and index. Copy has already been
given
started.
copies to Mr. Singh. We pass our order on 1 o'clock. We have 3 judgments. তাড়াতাড়ি ডেকে তো judgment. Initial time. We have discussed the arguments as advanced.
It all depends on the clients, my lord.
পরেরটা দাও। refuse to comment on. চলো ঠিক আছে
দেখে দিই
এটা একটু পাঠিয়ে দিও আমি সই
Central.
Well, I request your lordships to kindly consider your lordships' last order dated 27th November 2014. Oh, now, your lordships, I just draw your lordships' attention, my lord, to paragraph 4 and your lordships paragraph 7. So they have to come up with before lordship with a further report on that.
Yes, Mr. Dotto.
Mr. Mukherjee has deserted me.
He was holding fort all the while.
Yes, I find right at the beginning, one day I appeared. Thereafter, Milord, I had my personal problems, I did not appear. But today, Milord, I do not know where Mr. Mukherjee is. But I may require some time, Milord. It's really very embarrassing to come to court and seek time.
But is the implementation of the
I don't
undertaking
think I don't think anything further is being done. I don't think so.
My lord, according to
You
us,
should ask Mr. Mukherjee to file a report before you first.
Yes.
Yes,
my
Mr.
lord, according to our instructions, my lord, those notifications for recruitment are being proceeded with.
That would be inappropriate, Mr.
No, I do not know Milord, how it is being proceeded with.
এটা আরেকটা দুটো কপি আছে
Because you
আরেকটা
are
কপি দাও ওনাকে
free to recruit, or you are free to give admissions to the classes that were there before 2010. All
66. 66 classes.
Yes. Now, even in this respect of those classes, we are directed that you will conduct a review as to whether those classes are still backward after 14 years or for more than 15 years of reservation.
Yes.
So, when do you want to come back with the report? There is some urgency, or at least
No,
on the
definitely,
report.
definitely. Milord, a week's time will suffice. Kindly, if the business of the court permits me, next Friday.
জাজমেন্টের মুখস্থ বল কন্টেম্পটেই তো পাবি প্রথম প্যারাগ্রাফে
Is appearing. 7 and 8 in.
Appearing for the Senate.
So have you filed? You have filed the opposition.
Are you recruiting? Are you?
You have stopped the process.
Admission process.
There was an admission process going on post delivery of your lordship's judgment. That when the 2013 legislation was put under check, that was done with a notification that this is the result of the court's verdict. So whoever is joining, they have given an undertaking that we abide by this admission is to abide by the result of the proceeding.
So far as the 2013 challenge is concerned, not we, after that challenge thrown, not we have not admitted any student under the OBC category.
At least the universities are on the same page. We only want to know the recruitment process of medical officers and dentists and other people. That is the only issue.
No, Mr. Mukherjee, specifically, you
Yes,
were
yes,
not
those are
there.
recorded. Those are recorded.
You-
Those are recorded.
Now, Mr. Sannal, it is proceeding in what sense? Can you show us anything?
One thing I have, my lord, I have been instructed to say, of course, that is, I find as your losses, kindly have a look at this.
No, no, you tell us now,
And
Mr.
this is in regard to, my lord.
Shared a copy with the Advocate General also.
দুটো কেন আনিস? My lord, this is in regard to preparation of additional panel of 5% merit list.
Five?
Merit list. That is your lordships, a recruitment according to the primary recruitment rules, as your lordships know, that's recently come. The 5% recruitment, additional panel. As your lordship, both of your lordships knows. Additional. That is being proceeded with.
Which includes OBC A and B.
Obviously. My lord, I'm not saying anything. Kindly, Learned Advocate General, kindly look into this and come back with all.
I look into it and come back.
I'm not saying.
When do you want to come back?
Give us some reasonable time, your lordship feels. Whatever. Whatever.
Is the matter returnable?
I'm told 28th and 29th. Both days, the Honorable Supreme Court has expressed the views that they will continue with the hearing.
Yes.
Final hearing.
That's what I come to
That's
learn.
one.
That will go on.
Yeah, let that go on. Let that go on.
Oh, we are only concerned with interregnum.
Because some rights have been created, my lord. We have suffered for last 10, 12 years. And the other thing you lost is the writ petition. My lord, the state, I do not find any affidavit on behalf of the state, but the higher education department has, my lord, affirmed, filed an affidavit. They say, my lord, that they, my lord, or my lord, in respect of hearing that matter.
In fact, we have not been informed of any stay by the
No. Pendency.
Stay has been, in fact, disposed of, and I understand the main writ.
Main writ petition. Final hearing. Recorded
Civil
order.
appeal is going to be taken up to be heard.
Recorded order, final hearing.
That's what I also gather.
The stay application must be deemed to have been disposed of.
Being heard. Several dates have been heard.
এটা আমার কাছে আছে
fifth page, internal page.
চার পাতা খালি লই চার পাতা না 4.5
Order is of only 2 lines, my lord.
But the
array of lawyers
of the order has been rather wide.
Yes.
Which is most welcome.
This matters.
In regard to this, my submission in regard to the writ petition, which is we are questioning the Act of 2013. This pendency doesn't create any bar of proceeding with that, because the state has not, rather state has chosen not to file any affidavit. Higher education affidavit, according to me, that's an affidavit of the state. That's the department, higher education state department. They have said only the pendency. That they cannot say.
Milord, in virus matters, there's hardly any scope to dispute facts. If your lordships are inclined to hear that matter, we can come back prepared on the virus point. There's no difficulty. But so far as the
substance of their argument is this.
Yes.
The state has not conducted any separate survey for the 2013 Act. They have based themselves entirely on the classification made earlier. So their submission simpliciter is the same, for the same reasoning, this should also go. That is the sum and substance of what they are saying. Now, beyond this, and you have also made arguments in extensive in the earlier one. So there is nothing you can say to improve unless you have new facts. You conducted separate surveys. There was several directions there.
Now, finally, you have assistance in Mr. Mukherjee.
Yes.
Who has turned up.
No, no, don't deal in such a light manner, Mr.
He is our shock absorber. That's what I'm trying to say, that he is never to be dealt with lightly. He's the
Your
shock absorber.
He's a shock to the
No, he has held the state's forte very, very effectively over the decades. And we really appreciate that.
The problem is Mr. Mukherjee does not make us feel the age difference between him and us.
He mingles so very well.
Yes.
And he thinks that in every matter, government is right.
And that's the way it ought to be.
Right.
If you have no...
No, Mr. Datta won't agree.
Mr. Datta's methods are different. Where is your affidavit? You were supposed to file a report.
Affidavit report কত কিছু ফাইল করবে বলে গেছো হ্যাঁ বলো কত সময় লাগবে বলো
Give me some time, but 4 weeks time I will give you.
4 weeks.
But only difficulty is the admission of the students. But I think learned advocate will assist you.
We are only concerned that, in the 4 weeks you may give admissions and create.
No, they will lose the academic year. That's nothing more.
তাহলে তাড়াতাড়ি করে দাও না তাড়াতাড়ি করে দাও
তাহলে কবে হবে?
You said a week's time.
এক সপ্তাহ করে দাও এক সপ্তাহ 10 দিন
The more time will go, more difficult will get.
এখানে
Cause difficulty for all
right.
Students, recruited people.
Yes.
So it's best not to create rights in their favor.
2 weeks time I will give you.
আবার 2 weeks এক সপ্তাহে দিয়ে দাও না
28-এর আগে হবে তোমার মামলা কোনো অসুবিধা আছে
সেটা তুমি বলো 28-এর আগে রাখবে তো করে দেবো আমি 28-এর আগে
Just this part. Hearing including 2000.
Come.
Only one thing I just at the cost of repetition. I'm really pressing the new repetition also.
No, Mr. Sanyal, we are of the prima facie view that even the new writ petition will have the result of it or the argument, the SLB decision of the Supreme Court will have some effect.
No, I tell you.
We are conscious of the difference between 16.4 and 15.4. We are not on that, but there are substantial similarities also, to an extent.
That we will hear.
That we want to hear it.
All that I want, your lordships. I'm frank to your lordships. I'm speaking spade to spade.
No,
If
what
your
my
lordship
brother says
I
is
got
we
your
want
lordships.
to ascertain what step the state has taken. Which
That is the contempt.
Contempt. And so
Only
far
on
as
that for the time being. Let us wait for a conclusive final finding from the Supreme Court insofar as the 16.4 is concerned.
Well, I'm on the point. What would be the effect of the judgment of the most honorable Supreme Court in this present writ petition?
that we will hear, Mr.
No,
Sir.
that's some time, immediate hearing. That your loss. I tell your loss is why this is creating something. Your lawsuit has got that experience because of the running of these matters. But I got it at least 5 benches to get it heard. Not that your loss, because the court proceedings affects the hearing sometimes, changes of benches, all that. All that I'm saying, your loss.
We are at least clear on one thing, that we want to await the decision of the Supreme Court for the 2013 Act challenge. Let us do it. Even assuming the hearing is concluded on 27-28, which is a big question mark again. Their lordship will take some time to deliver judgment. You have to give them at least 2 weeks thereafter.
No, I tell you, losses, probably hearing of this writ petition will not cause much labor and pain to your lordships, because I tell your lordships, because our submission is very concise submission. The act itself gives the note, those who have been quashed. So your lordship,
Whatever your lordship's wisdom says, give that judgment, they can take it before the Supreme Court before that
No,
hearing.
let
Let us conclude it once for all.
It is very
That's my
clear,
point, your lordship.
28, 29 they are going to hear. So it is within, it is not that substantial period will be spent. Don't ask us to rewrite something which will again give, we want to finish it one slot for our.
Your lordship has finished it practically.
No, we
Right.
have,
Yeah, but
you
this
see,
one,
the state also needs a certainty from either way, whichever way. So for the contempt, we will fix it in a week's time or 2 weeks' time as, but insofar as the others are concerned, we want it to be after the Supreme Court judgment is delivered.
But kindly do not record that your lordship.
We are not saying anything.
Do that, your lordship.
We are not saying anything. We will simplicity adjourn the writ petitions.
On the next day, let us come back, your lordship. What happens then, your lordship?
When is the next?
Well, this is our affidavit.
In respect of the education, sir,
রিপ্লাই
কিন্তু নয় লিস্টে
বাবা তোমার কতগুলো ক্যালেন্ডার
এটা কোন একটা পেলাম আচ্ছা কবে দিয়ে দেবে
আচ্ছা একবার এপ্রিল মাসে দাও
সেইটাই বেটার হবে
আচ্ছা আচ্ছা ওই
এটা কোনটায় ফাইল করছো
অমলদাসে আমাদেরকে কবে দিবি না
দেবো তো এ কি দেবো তোমরা তো কিছু দাওনি
হবে না করবে না কিছু না খালি দেবে
7 and 8 হ্যাঁ একটু দিয়ে দাও রিপ্লাই দিয়ে দাও ওটাতে স্যার সেরা নিয়ে বলবে
আরে সৌমুখে দিয়ে যেতে
আগে তো কোনটা কাকে অনুযায়ী তখন কাছে বললো দেখ
তপনদার কাছে একটা বিল চেয়েছিলাম ক্লার্ককে বললাম যে পুরো বিলটা নিয়ে এসো আমি যে মাল নিয়ে এলো খুঁজে বের দুনিয়ার সব জিনিস এডুকেশন ম্যাটার লিবারেল সার্কুলার এসেন্সিয়াল কমোডিটিস এর সার্কুলার
সার্কুলারের ফাইলটা তো আমার কাছে ছিল ক্যারিয়ারের প্রথম দিকে সার্কুলারের ফাইল জোগাড় করে
16 তে কি আছে হ্যাঁ
তখন রিপোর্টের জাজমেন্ট
6 তে 3 তে কোনে রয়েছে
আর
16
ভালো লাগে ও জুনিয়র বলে দিয়ে নিয়ে আয়
3 তে সরি
তো সিস্টেমটাও বেটার হয়ে গেছে না
এখন লাগে না
তো come back we are keeping it on 16th then for the affidavit
Just for the affidavit, the contempt.
16 জানুয়ারি না 16
হ্যাঁ 16 জানুয়ারি
রায় তো 10 হয়ে গেল
তো কি হলো
হবে না
15 তো আসছে
এই দুটো দর্শককে দু জায়গা থেকে উঠে এসে পড়তে হবে
তুমি নিবে কি প্রসিড করছো না করছো না এইটুকু তো বলবে
all right we keep it on 24th 2 weeks he wanted na
he wants 2 months তাই তো
24th
কত 2 months চাই
24th 3:15 এ রেখে
24th
ফ্রাইডে
ফ্রাইডে এরপরে ছুটি আছে 23 তারিখে ছুটি আছে
ঠিক আছে 3:15 করো না আমি শেষ করে চলে আসছি
এই এক কাজ
অ্যাভয়েড
করে আমি চলে আসছি বেশি মামলা না ব্যাস হয়ে গেছে
don't avoid
Lord, we are all in a chorus not on 24th
okay
before after any day
keep it on 21st or your lordships immediately after that
আরে সরস্বতী পুজোর আগে বই পড়তে হবে
আমি তো কোনোদিনই পড়ি না
no there is a saturation point as regards getting knowledge you have reached that no further education required বলে দাও নিয়ে নাও হ্যাঁ 22 তারিখ 22
ঠিক আছে
কার সাথে
নাকি
হ্যাঁ পরের দিনই দাও
তার আগে তো বই চলে যাবে
23 করো ও 23 তো ছুটি হ্যাঁ তো 21 তারিখ
7 or 8 এর এটা
on prayer made by a learned advocate
21st
for expensive time to file report by way of affidavit
অসুবিধা নেই
না
report বলেছে
Highly report है
report by way of affidavit. Uh, as directed in this court's ordinary.
Well, read
The supplementary affidavit, your lordship directed us to file an affidavit.
no supplementary affidavit have been filed.
Main writ petition, sir.
Oh,
You want extension or not?
here extension.
Time to file
What's that?
affidavit now
Again.
to the main writ petition by the state at the request of the advocate general.
এটা কার কাছে থাকবে?
I did.
My lord, I am for the petitioner.
But have they intimated to you anything?
My lord,
Have they intimated to you anything as regards the status of those 3 appeals?
I know the status by obtaining a certified copy of the proceedings.
No, no, those appeals have been disposed of.
No, no. Still pending, kindly see, I have my lord, take copy of the certified copy. I recently obtained this certified copy of the appeal orders.
Those 3 appeals.
3 appeals.
Appeal state preferred 3 appeals.
3 appeals.
On those the orders have been
Yes,
passed.
yes. দেখুন হ্যাঁ এই যে দুটো দুটো দিলাম, দুটো আপিল, 2 আপিল সে দুটো দিলাম, একই জিনিস আছে।
ডিএলআর কাছে ছিল না?
ফাইল করেছে
হ্যাঁ,
রিপোর্টটা ডিএলআর
previous decision, but sure. এখন all are pending.
All are pending.
হ্যাঁ?
All are pending. All are pending, my lord. Last order, my lord. Last order. Last order. 21st April 2022.
So what do you want now?
My lord, only my prayer, my lord. My lord, before that, I only highlight only the what is the conduct of the state. My lord, this is a state versus state, my lord. A got up match, my lord, between the state versus state. My lord, SDLRO filed appeal against BLRO. My lord, BLRO complied the order of the Honorable High Court as well as the direction of the DLRO. Then, how the SDLRO filed appeal against those orders, my lord, after 6,252 days delay, 18 years, my lord, in order to deprive us, my lord, the British property of the British, clear violation of the Article 300A and 20 of the Constitution.
You are coming against which order of the tribunal? Which order you have challenged here?
Before here?
Here.
No, I have not specific.
So what is your prayer?
My lord, my
what
lord,
is your prayer before us?
My lord, no particular order, my lord, delay in disposing the.
When is the next date fixed?
14.
14th of?
January. 14th January.
So go and do the case there.
Yes, my lord. My lord, only direction I paid before your order.
Where is the order, last order passed by the tribunal?
My lord,
You have annexed an order of 2022.
No, a supplementary affidavit. Supplementary affidavit I filed, my lord.
Supplementary affidavit.
Your lordship,
Supplementary last order is not there. In para 7, you have stated that hearing has been fixed on 14th January 2025.
No, 15. The matter was fixed, my lord, 11/4/2023.
my lord, page 6 of my supplementary affidavit, my lord. I filed a supplementary affidavit, my lord, as per direction of this bench, my lord. Page 6. My lord, thereafter, my lord, after April 11, 2023, the 3 consequent date, my lord, the matter was adjourned before the tribunal.
What have you
because,
challenged? What have you challenged before the learned tribunal?
my lord, initially I challenged the inaction on the part of the authority.
PLR যেটা করে দিল রেকর্ডটা কারেকশন আটকে রেখে দিয়েছে যেহেতু এসডিএল এর অর্ডার এগেইনস্ট
অ্যাপিল করেছে না না এবার ও কি
আর কি এক্সপিডিশাস ডিসপোজ চাইছে
Now, where is the original application?
Original application.
You want to see the prayer portion. Page.
My lord.
Annex.
No, I have not annexed, my lord. So, but my lord, I challenge the inaction on the part of the authority concerned, that is the BLRO, because, my lord, to correct the record of right, pursuant to his own decision.
What order you want from us?
My lord, only, my lord, direction upon the concerned, my lord, tribunal to deal entire matter, my lord. The
entire matter means
means the maintainability of the appeal as well as our prayer.
No, you did not raise any objection that appeal is pending. All right, let us wait for some time.
My lord, when appeal was filed, my lord, I filed OA application before the tribunal in the year 2018.
So 14th is the date fixed. You go to the tribunal and say that let the appellate authority be directed to dispose of those appeals within a fixed time so that your matter can be finished.
My lord, my lord.
Go to the tribunal and say that this is the status of the appeals.
Yes.
You have the copy, you have obtained certificate.
Yes.
So they are not proceeding with the appeal since the matters are pending.
My lord, what happened?
You ask the tribunal that you fix a date within which they should complete the hearing of the appeal. Finish.
That illegal appeal, my lord, which was filed before appeal.
Illegal,
understood, but whether there is any quashing like proceeding, any provision
by the tribunal, yes, tribunal got that power to set aside those appeal because
appeal will be
not maintain
what
any provisions for appeal.
Let the appellate court, appellate forum decide the same. You raise the issue of maintainability before the appellate forum.
If the appeal is not filed maintaining the provisions of law,
you filed written notes of argument there.
No.
Mr. Gudia, you are not listening to us. You are unnecessarily arguing. We are talking in your favor. You are still here.
Yes, a direction may be given, my lord. That's why I have no objection.
No, we will say that 14th is the date fixed.
Yes.
14th is the date fixed, and on that day you will tell the tribunal that this is the status of the appeal. These appeals are not maintainable. Now and ask the tribunal to direct the appellate authority to dispose it within a particular time and take the maintainability before the appellate forum. Otherwise, you will not get that order from which you can come. Today, if the appeals are dismissed, then BLRO will have no other option to implement his order.
Yes.
Then the picture will become clear. But what we will say at this present?
Well, if the appeal is succeeds, suppose, my lord, for the
এখন আমরা কি বলবো ট্রাইব্যুনালকে বলতে হবে যে তুমি ডিসপোজ অফ করো
to examine all those.
আমরা কি অ্যাপিলেটরকে বলতে পারি না যে আমি এটা ডিসপোজ অফ করে দিচ্ছি, তুমি এই 3টে অ্যাপিল ডিসপোজ অফ করে দাও within a period of 3 months and place the orders before the tribunal. এই তো আননেসেসারি ম্যাটার গুলো পেন্ডিং রেখে দিয়েছে
হুম
নিজেদের মধ্যে।
তাহলে ওয়েটা চলে
না, ওইটা পেন্ডিং থাকবে। আমরা ডিএলআরও কে
এগুলো যথার্থতা চ্যালেঞ্জ করে বেসিক্যালি গেছে ও ট্রাইব্যুনাল। এখন ট্রাইব্যুনাল কি অর্ডার দেয় সেটা
না, এইটার যথার্থতা তো চ্যালেঞ্জ করে না। ও গেছে
তিনটে অ্যাপিলের তাই বলতে চাইছি যে অ্যাপিল গুলো চলতে পারে না। ট্রাইব্যুনালের কাছে গেছে বোধ হয়, ট্রাইব্যুনাল অ্যাপ্লিকেশনটা দেয়নি, টু স্টপ দ্য অ্যাপিল, মানে এইরকম কিছু একটা বক্তব্য।
You have not annexed your.
করেনি।
Where is your original application? You have not brought.
Yes, I brought.
Give it to us.
হ্যাঁ,
দেখি
Yes.
দিন তো। যথার্থ বলে তো বলেনি।
in view of the
commanding to correct the এটা হবে কি করে আনলিস দি অ্যাপিল।
My lord, only one page. Kindly see one page, my lord. Page 53, my lord, of this writ petition.
appellate authority কে ডাইরেকশন দিই ওইটা ইম্প্যাক্ট আসে, ওইটাকে ডিসপোজ অফ
ওইটা
14 আর যত তাড়াতাড়ি সম্ভব।
না, ওইটা তো করেছে যে ফর ইমপ্লিমেন্টেশন অফ অর্ডার অফ
বিএল।
এবার ওরা বলেছে যে তিনটে অ্যাপিল পেন্ডিং আছে, এসডিআর ও বিএলআর এর অর্ডারটা এগেইনস্টে গেছে,
চ্যালেঞ্জ করে দিয়েছে। এবার অ্যাপিল গুলো না ডিসপোজ অফ হলে
এটা হচ্ছে না।
এটাও করা যাবে।
ট্রাইব্যুনাল ওইটা এটা অবজার্ভ করে নাও যে আনলেস অ্যাপ্রোপ্রিয়েট ডিরেকশন ইজ ইস্যুড বাই দি ট্রাইব্যুনাল। আমরা কেন
মানে সব জড়িয়ে ফেলেছে, অ্যাপিলটাই লড়াই করা উচিত ছিল ওই এবং এইসব।
অ্যাপিলটা কি করে লড়াই করবে? পার্টি।
হ্যাঁ, পার্টি দেবে।
You are parties to the appeal.
হ্যাঁ,
Appeal, but no copy was, there is a provision, notification in the notice board by the DLRO. Declaration may be made by the party to serve the copy to other side. He has not served upon me. I obtained a copy, certified copy from that forum. Well, kindly also conduct of the appellate authority 53. Only 1 minute, my lord. How they conduct? Only 1 minute. Kindly my request.
এইটা এবং ওইটা
Page 53, my lord.
ডিসপোজ অফ দ্যাট।
Only page 53. Can you see how they condoned the delay for 6,252 days? My lord, can you see?
Delay has been condoned.
Yes, delay condoned without giving me any opportunity.
You could have challenged the state order also.
That's why the
what you have
tribunal can
filed-
decide all those things, my lord.
Not to correct. You have filed an application
My
in the direction not to correct the code of right.
Yes, own decision. DLRO directs the BLRO. BLRO passed an order in our favor, but record of right not yet been corrected. That's why we moved before the honorable tribunal.
Why didn't you challenge the order by which the limitation was allowed by the DLRO? Page 54.
Yes,
You should have challenged this order. That how you can condone the delay of 3,000 so many days.
3,000 not, 6,000.
6,000. So you did not take step against them.
Tribunal can decide. Tribunal.
Where is that? You have challenged that order?
No.
Everything
No,
tribunal.
no.
Have you said
No.
that order is bad?
No.
Then where you are saying? Why you are saying tribunal will?
As per direction of the.
Whose direction? Have you ECT or prayer?
I filed before that appeal, filing that appeal. Appeal was filed in the year 2000.
So why didn't you say that you could have filed a supplementary evidence saying that this order has been passed?
My lord.
Yes,
Yes, I can do so.
So what do you want?
My lord, the tribunal can decide entire matter, my lord, in accordance with the law, my lord, what happened? Rejection may be passed upon the tribunal to look into the matter.
ডাইরেকশন দিয়ে দিবি আমাকে যেই
we will dispose of the original application as well as the writ petition directing the DLRO to dispose of the appeal within a particular time. Will that serve your purpose? তাহলে ডিলে টিলে কন্ডন হয়ে গেল, নো ফার্দার চ্যালেঞ্জ ইউ ক্যান মেক।
Yes, that's
থিঙ্ক ওভার, এতক্ষণ বুঝিয়ে টুঝিয়ে এই কার
1486 proceedings was initiated by the BLRO suo motu.
no, as per direction of the appellate authority, pursuant to the order of the Honorable High Court. High Court 3 times rule issued, one against the BR case under the provision of.
Will we dispose it of asking your DLRO to dispose of the appeal? Are you agreeable to that? Think over.
Mala strictly in accordance with law.
আবার বলে strictly in accordance. Your limitation point goes, if we pass this order, then you cannot challenge that order by which the delay was condoned.
Yes,
You will not challenge also 2021 delay was concerned. You're sleeping. This repeat এটা কয়বার কয় ফাইল 18। You should have immediately you filed this before the appeal was preferred. This original application. Before appeal was preferred, you file this application.
Yes.
In this application, you have to now.
Yes.
That after it is a miss case 02 of 2010. An appeal has been filed against miss case number 32 of 2006.
No. Three appeal. 3 appeal has been filed. 3 appeal. 03 of 2023. 14 of 2003. My lord. 3 appeal has been filed. My lord, 3 appeal. There are 3 appeal.
The appeal against which order? Order passed connection with which miss case?
I am telling my
What
lord.
is the number of that miss case?
My lord, appeal number 196 T of 2020. 196. Within bracket T of 2020. Has been filed against the order dated 25/11/2003 in miss case number 14 of 2003.
25/11/2003 in miss case number?
Against the order dated 25 November 2003. In miss case number 14 of 2003. Against the miss case number.
Yes.
Second, my lord, appeal number 195 T of 2020, which has been filed challenging the order dated 12/2/2009. 12/2/2009. In miss case number 32 of 2006. And appeal number 197 T of 2020, which has been filed challenging the order dated April 30, 2010 in miss case number 2 of 2010. The last order passed by the concerned BLRO pursuant to the direction of the DLRO. DLRO asked him to initiate proceedings and dispose of he.
Now you challenge, you filed the original application seeking a direction to correct the record of rights in accordance with the order passed in miss case number 2 of 2010. That is which is the subject matter of the appeal being 197.
Now 197.
Now in respect of other 2 appeals, how we will interfere?
I will not file appeal. Appeal filed by the SDLR. SDLR filed the appeal against the earlier.
You before us challenging the in connection with this OA.
Yes,
this
everything.
OA subject matter of this OA is miss case number 2 of 2010. according to your pair.
Inaction, only inaction, my lord. There is, I have not challenged any order. Inaction on the part of the authority, nothing more.
My lord, your lordship,
স্ট্যাটাস রিপোর্টটা এখানে ট্রাইব্যুনাল
এই দুটো একটু দিন।
বলেছে যে স্ট্যাটাস রিপোর্টটা কি স্ট্যাটাস রিপোর্টটা
শুধু এটা 97 এই দুটো আমি উল্লেখ কি করতে পারি?
দেখি
My lord, at your lordship direction, my lord, I took the instruction, my lord. All the appeal is pending, 3 appeals before the district land and land reforms officer.
অ্যানালগাস হিয়ারিং হচ্ছে তো
Appeal গুলো, হ্যাঁ।
তুমি 14 তারিখের ডেটে শুনে নিতে পারো স্ট্যাটাস রিপোর্ট এখানে ফাইল করেছে কপি দিয়ে লেট দি ট্রাইব্যুনাল ডিসপোজ অফ দি অরিজিনাল
গঙ্গাধর পালকে?
ডিসপোজ অফ
My lord, one of the Sevait stated, I have filed an application. I have filed an application before the honorable court, my lord, and for that reason that all the appeals were stayed.
No, I asked a copy. Nobody said that.
My lord, if your lordship will come to the order.
Mr. Day, if we direct the DLR.
Yes, my lord, DLR will dispose of. Yes, my lord, within certain time. Yes, my lord, I am.
In the circumstances, we have to dispose of the OA and the present petition.
Yes, my lord.
Are we agree?
Yes. Yes, my lord, your lordship can. That is the order. That will be the order.
But this OA is not, other 2 appeals is not subject matter of this OA.
Whatever may be that, my lord. All the 3 appeals is there by the. All the 3 appeals should be disposed of. But that is a very bad practice, my lord. That he filed an application. He filed an application before there. And after that, filed an application.
Please
But
show me.
Well, application. এটা কার application?
আর application এটা তো এখানে
গঙ্গাধর পাল, তুমি বলছো one of the সেবাই।
আর সে তো এখানে
আচ্ছা you are neither the sebai nor the landlord, you are an advocate. Wait.
আমি ওখানে বলেছি, ও তো বলেছি ডিএলআরও আমার কপিটা পেয়ে
আমার দুটো সার্টিফাইড কপি দিয়েছি অরিজিনাল দেন তো। আর আমার